DB. DB.
For hearing, item number 1.
Pardon. DB. Enggak DB nak?
Yes. I'm placing the service rules because Lordship, there are several service rules which has been enacted over the years since 1966. Give the third amendment. So for reading references, including the third amendment, Lordship, copies of all the service rules.
Yes.
And I'll be referring to all the service rules in course of my hearing, Lordship. In course of my hearing, Lordship, by submission, I'll be referring to all the service rules. In fact, Lordship, for easy references, I'm keeping all the service rules until the third amendment, so that instead of going through the petition, I can easily refer to the service rules. Lordship, yesterday, the Learned Counsel for respondent number 1, 2, and 3 and submitted many untrue grounds for your Lordship recollection. Firstly, Lordship, on the question of maintainability and the question of eligibility of the private respondents and the writ petitioner appellant. A lengthy submission was made by the Learned Counsel, Senior Counsel for the appellants on the maintainability, which I'll come later stage. To that, he had given a submission. He had Lordship pointed out the paragraph 21 in the writ petition, where it is categorically mentioned in page 68, paragraph 21, that in view of the third amendment, both the writ petitioner appellant and private respondents are eligible. That was so in that view of this paragraph 21, Lordship, the eligibility issue has been decided, and that has been clearly stated in paragraph 21. And in that view of the matter, the learned single judge did not move into the issue of eligibility, but only on the issue of rules, which rule will be applicable. That was his first submission. Then, Lordship, by referring to paragraph 26, the learned counsel for respondent number 1 to 3 on the question of grievance of non-consideration of and the alleged non-consideration of the appellant petitioner, that she is not considered for promotion to the post of secretary. Lordship, the reports were placed before this honorable court yesterday, and the court speaks for itself that the learned speaker had recommended considered and recommended both the petitioner and the private respondent. That was pointed out, which is really clear from the reports. And which rule will be applicable, 12 and 15, which rule will be applicable? Lordship, he has made an extensive submission. So I'm endorsing this submission, subject to reiteration in some important points of his submission, which I think is relevant for to decide this case. Keeping that in mind, Lordship, before I go to the other submissions, Lordship, you kindly allow me to highlight what is the prayer in the writ petition. Lordship, subject to the Lordship, you kindly go to page 72. the prayer of the writ petition. What is the specific prayers of the writ petitioner? Appellant. One, please to make the rule absolute in the following terms. Please to make the rule absolute in the following terms. To quash and set aside the new notification within 25/3/2026. Two, to direct the respondent authorities to constitute a DBC for regular promotion by duly considering the case of all those who are in the zone of consideration for the post of secretary. These are the two specific prayers. Then, Lordship, we kindly come to the judgment of this honorable court. Of the learned single judge. Lordship, we kindly see the judgment of the learned single bench is at page 35, page 26 onwards. Then, Lordship, at page 48, paragraph 35. In the light of Lordship, paragraph 35. In the light of the above discussion, this court is unable to order that the exercise of promoting respondent number 4 by the notification dated 25/3/2026 is bad in law or manifests. So, Lordship, the specific prayer was rejected by this honorable court, by the single judge. Then, Lordship, we kindly come to the prayer of the writ to the present writ appeal, which is at page 26. Relief pray for in the writ appeal. Very Lordship, in the premises of possibilities respectfully prayed that the Lordship may be placed to admit this writ appeal, both for records issued and notice respondents should oppose as to why the appeal judgment dated 8/5/2026 part of the single judge in 40/2026 should be quashed and set aside, and after hearing the parties, the Lordship will be pleased to quash and set aside the appeal judgment dated 8/5/2026 passed by the single judge in 2040 and allow the writ petition. Well, the specific prayers before the letter single judge was to set aside the notification dated 25/3/2026 and the direction to conduct a DPC, which Lordship we have just referred to. However, Lordship, here that specific prayer has been abandoned. The simple prayer is to quash and set aside the order dated 8/5/2026 and allow the writ petition. It is general in nature, whether this honorable court can give a direction to allow the writ petition which is already dismissed. Now, Lordship, can you allow me to refer to CPC? Lordship, can you allow me to refer to Mother Order 7? Can you allow?
CPC.
CPC. Civil procedure.
Yes, civil procedure law. Lordship, order 7, rule 7.
Relief to be specifically stated.
Yes, Lordship.
Right. You got the book.
Lordship, we can read. Can you allow me to read? Every plaintiff shall state specifically the relief which the plaintiff claims either simply or to alternative, and it shall not be necessary to ask for general or other relief which may always be given as the court may think just as to the same extent as if it had been asked for, and the same shall apply to any relief claimed by the defendant in the pleading state. So, my lord, the relief has to be specifically stated, not in a general manner. That is what Order 7, Rule 7 says. Now, my lord, admittedly, when the writ petition was filed, in the writ petition, there were two specific prayers. However, in the present writ appeal, Lordship, the two specific prayers has been abandoned, and it only says, my lord, one should set aside or judgment and allow the writ petition. And the two specific prayers has been abandoned, given up. My respectful submission is, well, a specific prayer was there before the letter single judge that was specifically rejected in para 35, which I have shown by the letter single judge. So, Lordship, when the writ appeal is filed before this another court, beside a prayer to set aside the judge, the new judgment, that two specific prayer to quash and set aside the new promotion and a specific prayer seeking a that direction to conduct the DPC should have been there. And that is afforded by Order 727, that the prayer should be specific and not general. So, my lord, words of the words for the respondents, even if the petition is allowed, reserving the thing is allowed, and set aside the judge, the new judgment, but the promotion orders will still remain independent of this. So, in my respectful submission, since the two specific prayer has already been given up, abandoned by the writ petitioner in the present writ appeal, filing of the present writ appeal is only academic in nature. It is only an academic exercise because whether this honorable court will not allow this writ appeal or not, the fact remains that my promotion order shall remain independent of this. And Lordship, I am reiterating that this honorable court, whether under what circumstances, how do we define allow the writ petition? When it is only repetition of the earlier prayer to quash and set aside. To quash and set aside the new order, judgment order, the 8/5/2026. That is allowed. So, my lord, that is my first objection in the present case. Now, secondly, Lordship, so, my lord, this because Lordship, the time in again, the Honorable Supreme Court has held that parties should specifically lead their prayers into play or in the petition, and the Honorable Courts cannot constitute the prayers. It is not the duty of this Honorable Court to find out the prayers. So that is the first submission on present case. Secondly, Lordship, when the letter single judge had decided the BBC 40 of 2026 by the Indian judgment order dated 8/5/2026. Lordship, it was unlike other cases. It was not a fresh case, fresh facts decided by the letter single judge. There was a long history of litigations. Lordship, there were 6 other rounds of litigations, and the BBC 40 was the 7th round of litigation on the same subject matter. So, Lordship, the letter single judge, in fact, during the course of hearing before the letter single judge, because the categorical opinion of the letter single judge that the letter single judge, as a matter of judicial discipline, was bound by the findings of the coordinate benches, and especially the judgments in the good division by the good division bench of this honorable court. So, my lord, the legislating judges passed the reviewing judgment, keeping in view the earlier 6 round of litigations and in tune with the findings of the earlier 6 round of litigation, this judgment was delivered. So, my lord, this honorable court, in my respectful submission, has to keep that in mind, because under what facts and circumstances the legislative judge has passed the present review judgment. So, my lord, this honorable court should have a sense of the 6 other judgments to appreciate under what circumstances the single judge has passed this present case. Now, I will refer to some of the paragraphs in due course of hearing, but briefly, Lordship, I filed the WBC, the great respondent, filed the WBC 40 Kia of 2026, seeking a direction that my representation be disposed of. For non-disposal of my representation, I approached the local court in the WBC 40 of the WBC 20, the WBC 20 of 2021, and by order dated 9/7/2021, this honorable court disposed of my writ petition with a direction to the honorable speaker to dispose of my representation with the speaking order. Under what circumstances I submitted my representation, I'll show the facts later. Accordingly, by a speaking order, my representation was disposed of, and pursuant to that order decision, the honorable speaker had passed the office memorandum 1/11/2021, by which the services in the Nagaland Legislative Assembly was restructured. And thereafter, an order was passed also simultaneously on 1/11/2021, by which I was recognized in the general matter in the grade of additional seat. I'll be referring to the judgment, Lordship, kindly just get a sense of the orders. Now, my lord, the service rules are enacted under Article 147(3) by the governor. So, for restructuring of the rules, it is the governor, not the speaker. However, Lordship, when the office memorandum 1/11/2021 and order 1/11/2021 was passed by the speaker, which should have been done of it by the governor, honorable speaker, in exercise of the residuary power, these orders were issued. It was challenged by them. Now, the legislative judge, on the ground of legislative competency, not on the ground of legislative competency, that the speaker does not have the power to restructure the rules, that is only the governor who has the power to restructure the rule. The office memorandums and orders were quashed and set aside. But appreciating the fact that there is genuine grievance of the resident respondent level 4, this around the court has given the liberty to the government respondent authorities to restructure the rules. Thereafter, the service rule was restructured. Then the third amendment, by notification dated 18/5/2022 was enacted, which made everyone, chief secretary and above, followed with no distinction, and everyone was made eligible. So I also became eligible. Thereafter, pursuant to the amendment of 18/5/2022, by order dated 5/7/2022, a temporary charge of secretary was given to me. Take note of the fact, I'll show them that even for the purpose of temporary charge, one should be eligible. You cannot give the temporary charge of secretary to a person who is not eligible under the rules. So, I being eligible, I was giving the temporary charge. Now, the President Appellant filed the WPC 144 of 2022 and challenging the temporary charge on the ground that she is a senior most and I'm not eligible. And an interim order was passed down to 22/7/2022. Thereafter, I filed an IA IA 116 of 2022, and by an order dated 12/8/2022, the interim order was vacated. Well, vacating the order, the legislature judge had come to the conclusion that it is the post of additional secretary, the selection post, and seniority is not a required criteria. In fact, the legislature judge had come to a conclusion that seniority between us is yet to be decided. I'll come to the judgments. Thereafter, a writ of 2022 was filed against that. Now, by an order dated 3/9/2024, my lord, the writ appeal was dismissed. And the finding of the writ of Parliament is that by then, by us on 3/9/2024, everyone is not eligible. In other words, the finding by the single judge was upheld. In that view of the matter, on 5/9/2024, the reserving appellant had withdrawn the WPC 144 of 2027. In other words, accepting the findings in the IA and in the writ appeal. Thereafter, Lordship, the association and the writ petitioner appellant had filed the PPC 92 of 2022 before this and court, challenging the amendment of the rule. Now, I'll refer to the relevant portions, paragraphs, what we have submitted then, under what grounds these rules were challenged. And in fact, the grounds taken that in those earlier petitions, the submissions, and now the submission of the senior counsel is exactly the same. I will show the relevant paragraphs of this submission. Now it was rejected. The challenge to the rules was rejected in Woodland Amendment upheld. Thereafter, on 33/2026, I was recognized to the post of secretary. Now the record will show, because the other day report, everything was shown before this report. After 33/2026 was passed, the Office of the Accountant General had pointed out the defects to the Assembly that it should not be regularization, but it should be promotion. So when it was reprocessed, and on 26/5/2026, a corrigible was issued superseding the earlier order, whereby I was shown promoted. Accordingly, the PPC 33 of 2026 was withdrawn on 36/2026. Now, the senior counsel were making a submission that on 26 the petition was moved. We appeared that day, and we did not bring the notice of the court that the order of the earlier order has been now 33/2026 had already been superseded. But on 26, Lordship, without filing power, simply on telephonic instruction, we came before the honorable court and made a prayer that we have been instructed, kindly allow us to file power and we'll produce a report. That much, because after filing power, we received all the necessary instructions. Accordingly, the report was produced and thereafter it was withdrawn. And the PPC 40 of 2026 was filed thereafter. So this is the sequence of the litigations. This is the 8 round of litigation. If we see the orders, it will be more than that. So that is what that is how when I filed my affidavit in opposition, I have raised 3 grounds, 3 preliminary objections on the maintainability of the petition. Lordship, if Lordship may kindly see my affidavit, paragraph 258, page 258. Page 258 is my affidavit in opposition. And at paragraph 2, I had raised 3 preliminary objections on the maintainability. The 3 grounds was firstly, Lordship, that the petition was filed relying upon the effective service rule. That is my first ground. Second ground is non-joinder of necessary party. That the that the Honorable, that the Secretariat of the Honorable Governor and the Secretariat of the Honorable Speaker has not been made part, and the Secretariat of the Honorable Governor and the Secretariat of the Honorable Chief Minister has not been made party respondents. So in suffers of non-joinder of necessary party, that was the second ground. And third ground is the ground of constructive res judicata. That the earlier 6 rounds of litigations, all the issues have been decided. So to raise all those issues all over again is part by the principle of constructive res judicata. These are the 3 grounds raised. Now, Lordship, in my to that reply, Lordship Megani put an affidavit in reply of the present appellant at 318. 318 is the affidavit in reply, and Lordship may kindly see paragraph 5 and 6. In spite of notice that there is non-joinder of necessary parties, Lordship, in paragraph 5, the appellant has made a categorical stand that the Secretary of the Governor and Chief Minister are not necessary party. That is ground number paragraph 5. And in paragraph 6, Lordship, if the Lordship kindly see the last 6 lines on the bottom of paragraph 6 time, the letter he made a categorical statement that constructive res judicata is not applicable. Now, my Lord, I shall, by referring the judgments, I shall, by referring to some relevant few more paragraphs of the previous round of litigation, I shall try to convince the portion of the on the question of constructive res judicata, but my Lord, on the question of non-joinder of necessary party. Kindly allow me to make a submission now that on question of non-joinder of necessary party. Now, Lordship, after the third amendment, my Lord, in the Principal Act, it was, and the governor will appoint the secretary in consultation with the chief minister, in consultation with the speaker. My Lord, Act of, my Lord, the 1990, the principal rule.
It is rule 12.
Yes, rule 12. It should be, my Lord, rule 11 in the principal rule of 1990. That is the first one after 66. After 66, not the second one is rule of 1990. The first one I have given is the rule of 1996, then rule of 1990, Lordship. In the Principal Act is rule 11. The appointing authority, the secretary shall be appointed by the governor in consultation with the speaker. And Lordship, in the third schedule of the Principal Act rule, my Lord, by promotion from additional secretary with minimum of 2 years continuous service in the grade or as may be deemed fit. Or as may be deemed fit. The word or is there. Lordship, I have given it in sequence. First is 1996 rules. The second one is the principal rule of 1998.
This is 1966.
So, Lordship, my ladyship may kindly see the next one. Rule of 1999. Principal rule of 1999. Yes. Without the amendments. It is given in sequence. Lordship, may kindly see rule 11 there. Rule 11. Then that is the secretary shall be appointed by the governor in consultation with the speaker. Then kindly see the schedule. The first schedule. No, the second. No, kindly third schedule, see rule 10. Third schedule. third schedule C rule 10 is under, I marked it like this. By secretary, by promotion, liquidation, direct, then on the right, grade from which promotion will be made by promotion of additional secretary with minimum 2 years continuous service in the grade. Lordship may kindly see, mark the word or as may be 10 feet. Lordship is following?
Yes, yes.
So the word or was there in the principle rule. So or as may be 10 feet. So as may be 10 feet was optional with the word or. Now Lordship may kindly come to the third schedule, which of 2022.
Third schedule of 22.
The latest one. I have given in a single sheet. It will be in the bottom.
Yes, this one.
Yes, that one. Lordship is it will be the yes. Now Lordship may kindly see at column 5. The secretary and additional secretary shall be appointed by the governor on the recommendation of the speaker in consultation with the chief minister. Then can you see the next page, the third schedule? For secretary, now it is amended by promotion from the grade of additional secretary or equivalent in the secretary, assembly secretary with a minimum of 2 years continuous service in the grade, comma, if deemed fit by the appointing authority. The word or is now deleted. The word or is deleted. So it is now, the option is not there. The point I'm making is, I'll be coming to this rule again, but for the purpose of non-joinder, I'm making a submission, Lordship. Now, Lordship, the Honorable Speaker is the recommending authority. Honorable Speaker is the recommending authority. Honorable Speaker will only recommend. Who are eligible? Thereafter, Lordship, the appointing authority is the governor. And Lordship, a discretionary power is given to the Honorable Governor. 2 years continuous. Kindly allow me to read the third schedule again. With a minimum of 2 years continuous service in the grade, comma, now the word or is deleted. If deemed fit by the appointing authority. So who is fit? Under recommended names by the speaker, who is deemed fit is to be determined by the Honorable Governor in consultation with the Honorable Chief Minister. Honorable Speaker is only a recommending authority here. Honorable Speaker plays the rule of PPC. The Honorable Speaker is functioned as has taken over the rule of PPC. He is only recommending authority. So whoever is eligible, who is in the zone of consideration with all the CVs, that has been recommended. The report has shown. Thereafter, Lordship, amongst the recommended names, who is deemed fit to be appointed, that discretionary power is given to the Honorable Governor, and the Honorable Governor can exercise that power only after consultation with the Honorable Chief Minister. In fact, the three highest authority other than the Honorable Chief Justice are converging and getting a joint decision here, recommending, consultation, and appointing if deemed fit. Now in normal PPC Lordship, once the PPC recommends, Governor under 309. In the case of PPC under 309, once the Governor recommends, once the PPC recommends, the appointing authority may accept, may not accept with reasons. Here, beyond that, my lord, the Honorable Governor is given the power, discretionary power to decide who is deemed fit. That is why, Lordship, the respondent number 1 or 2 and 3 all along has been making a submission that the post of secretary is a selection post. Because Governor, Honorable Governor, in consultation with the Honorable Chief Minister, have the discretionary power to select. And the condition is any person in the grade of additional secretary or equivalent who have 2 years continuous service. Minority does not come into play. The only criteria is 2 years continuous service. Lordship, may kindly appreciate, Chief Secretary is a selection post. Any IAS officer with 30 years of service is in the zone of consideration for selection. No TBC for secretary. The chief secretary of the cabinet will select as the cabinet secretary and governor. So, my lord, in that situation, my lord, only the recommending authorities were made party respondents here. 1, 2, and 3. Respondent number 1 in the present, in the writ petition, in the writ appeal is an Honorable Speaker. Respondent number 2 is the Secretary. Respondent number 3 is the Joint Secretary who has initiated the fight. Only the recommending authorities were made party respondents, but the decision-making authority, the Honorable Governor and the Honorable Chief Minister, were not made party respondents. So, my lord, before the learned single judge, I have made a preliminary objection on non-future of the necessary party. That look here, only the recommending authority is made party respondent, and the decision-making authority has not been made a party respondent. In fact, the secretariats of the Honorable Chief Minister and Honorable Governor should have been made respondent, which were not. Now, in spite of notice, Lordship is well aware of non-future necessary party, the discretionary powers is always there with the Honorable Court in civil proceedings. Now here, I have filed my objection, raising preliminary objection that look, pointed out to giving notice to them that your petition is defective, there is a non-future necessary parties. I pointed out that opportunity was given to them. In spite of that, he filed a reply affidavit to say that no, it is not necessary. So that chapter is closed. So in that view of the matter, my lord, in the absence of the secretariats of the Honorable Governor and the Honorable Chief Minister, who are the decision-making authority for promotion, for selection and promotion of the secretary, whether the petition is maintainable. Now, going by the arguments of the learned counsel for the appellate, he was also saying that first there should be a TPC, then it will be put up to the speaker and governor will appoint. That was his theory. Whichever you look at it, either we go by his theory of that the 2 rules, put the rules should be applied, or whether we go by our stand of the respondent number 1 to 3. The fact remains that the decision-making authorities are not before this honorable court. So, my lord, the petition from the very beginning suffers from non-future or necessary party, and since this is an intra-court appeal, my lord, I have every right to raise this issue even at this stage. Now, on the issue of constructive res judicata, Lordship, I will be referring to the judgments. So when I refer to the judgments, that will show that clearly show that the constructive principle of constructive res judicata applies except on the applicability of Rule 12 to 15. Now, my lord, coming to the rules. My lord, this is one of the rarest of the rare case before the High Court, because hardly we have checked, my little friend, we all checked the previous rulings on this, except for the whole case in Assam. We have not come across any judgments for seniority dispute or promotions under assemblies and the rules under Article 187(3). So it could be a landmark in the future. Now, my lord, Rule 309, Article 309 proviso to Article 309, governor have the power to make rules. That now, Lordship, kindly allow me to refer to Article 187(3) to get a sense of Constitution. Article, kindly give the Constitution.
187.
Yes. Lordship, since the Assembly is here to enact the rules, I'm only, my Lord, 187(1). Kindly allow me to read Article 187 in whole, because the Secretariat of the State Legislature, 1. The House or each House of the Legislature of a state shall have a separate secretarial staff, provided that nothing in this clause shall, in the case of the legislature of a state having a legislative council, be construed as preventing the creation of a post among the court houses of such legislature. 2. The legislature of the state may by law regulate the recruitment and condition of service of persons appointed to the secretariat staff of the House or the houses of the legislature of the state. 3. Until provision is made by the legislature of the state under clause 2, the governor may, after consultation with the speaker of the legislative assembly or the chairman of the legislative council, as the case may be, make rules regulating the recruitment and conditions of service of persons appointed to the secretary staff of the assembly or the council, or any rule so made shall have effect subject to the provisions of any law made under the said clause. So, my lord, in the present case, all the rules were made under 187(3) by the governor in consultation with the speaker. Now, Lordship, the difference between a rule made enacted under proviso to 309 and rule made under Article 187(3) is, my lord, Honorable Speaker have under, or in all the rules made under Article 187(3), or for that matter 182, Honorable Speaker have plenary powers under the rules. Honorable Speaker have the recituary powers. Honorable Speaker have power to interpret the rules. Honorable Speaker have power to remove difficulties. Unlike other normal service rules under 309. Now, Lordship, the first rule was 1966 rules. Lordship, now kindly allow me to quickly refer to some of the provisions of 1966 rules so that you get a sense of how the rules were evolved. It is important to appreciate so that how the amendment was put up, that has to be appreciated, Lordship. Now, Rule 3, strength of secretariat, its strength and composition is mentioned. Then, Lordship, Rule 4, then Lordship, we kindly come to Rule 9. The Rule 7 is the method of recruitment is Rule 9. Lordship, by promotion, by permanent transfer, by direct recruitment, speaker may by time. These are the 3 conditions. Then appointing authority, Lordship, is a paragraph Rule 9. The secretary shall be appointed by the governor in consultation with the speaker and the State Public Service Commission when constituted. So in the original service rule, for the post of secretary, post has to be appointed by the governor in consultation with the Honorable Speaker and Nagaland Public Service Commission. Then, Manot 9.2, all other appointments to post shall be made by the Speaker, provided the Speaker may, by general or special order, delegate to the Secretary his power to make appointments to any post or class of post specified in such order. When persons appointed to the Secretary under this rule before coming into force of this rule shall be deemed to have been appointed by the Speaker. So, my lord, a clear distinction was made between the post of secretary And the other post, how you be appointed. My lord, up to the rank of additional secretary 9(2), and for secretary 9(1). That was the original rule. 9 of 1966 rules. Then Lordship, you kindly see the schedules. The schedules, my lord, then my lord, prior to that, receivatory powers. Rule 25, interpretation. Rule 26, the power of the speaker is given in 25 and 26. Now, my lord, in the first schedule, my lord, if Lordship may kindly see, no distinction was made. All the services, all under Nagaland Secretariat was treated as one. There was no classification. There was no distinction between different wings. All were treated as one, single general of promotion, and no distinction was made like general cadre, non-general cadre. No distinction was made in the original rules. And in the original rules, the assistant transport and committee officer where we were entered, that service post also was not existing in the year 1966 when this original rule was made. So, my lord, this is 1966 rules. Thereafter, Lordship, we come to the Principal Act, 1999. Lordship, we kindly see the first page. By a notification dated 27 July 1999, Governor in power exercises the power under Wing 87(3). The rule was, a new rule was enacted. Then, Lordship, we kindly see N. 2M. 2M and the service means the service of the Nagaland Legislative Assembly Secretariat. The leadership has found that? Yes. Then, Lordship, you kindly see appointing authority 11, my lord, 9, 10, and 11. Method of recruitment by promotion, by deputation, by direct recruitment at 9. Then qualification for recruitment and promotion as provided in the third schedule at 10. Then appointing authority, Lordship, the secretary shall be appointed by the governor in consultation with the speaker. Appointment to all other posts shall be made by the speaker, which time and again we have referred. So I'm reiterating that again. Then, Lordship, come to 14. The TPC. Chairman, for all cases of recruitment by promotion and selection, there shall be a TPC consisting of the following: Secretary, Chairman, Additional Secretary, Joint Secretary, Under Secretary, Chief of Editor. Mala, kindly appreciate this fact: Secretary is the Chairman. Now, an argument was raised the other day by Counsel for Respondent 1, 2, and 3. When promotion for the post of Secretary is to be considered, additional secretaries are also out because they are in the zone of consideration, and whether people in the lower grade can assist officers in the higher grade. And Lordship, in the absence of secretary and additional secretary, who will be the chairman, if that is allowed? Another issue, Lordship, may kindly appreciate the fact that up to the rank of joint secretaries, who writes the ACR? The secretary. Secretary writes the ACR of the junior officers. So somebody, a junior officer, whose ACR the secretary or will be written with a third authority, can decide and assess the merit of secretary, additional secretaries for promotion to the post of additional secretary. So those are the issues which were raised. I'm only repeating. Now, Lordship, may kindly come 17. Rule 17. Subsequently, it was renumbered as 18, but I will explain how it is renumbered. All office control and discipline, all officers in staff in the Assembly Secretary shall be subject to the superintendence in control of the Speaker, provided the Speaker may, by general or special order, delegate to the Secretary any of his power in this regard or any of the senior-most officers in the absence of the Secretary. My Lord, Proviso to 17 is the power for to give temporary charge to any of the senior-most officers in the absence of the secretary. Any of the, Lordship may kindly take note of the word any of the senior-most officers in the absence of the secretary. I will come to this provision. By interpreting this, the learned single judge in the earlier also said that secretary the selection focus any of the senior-most. This is for the purpose of temporary charge of secretary. Then Lordship, residuary powers in 21. 22 is the interpretation. Lordship may kindly allow me to read 22. Subject to the provision of these rules, all questions relating to interpretation of these rules shall be referred to the speaker, whose decision shall be final. So, my lord, I have relied on Rule 22 in my before a learned single judge, removal of difficulty, Rule 23. Now, Lordship, kindly see the schedules, first schedules. Lordship, may kindly see the first schedule, serial number 20, 20, 21, 22. Assistant Committee Officer, Assistant Research Officer, Assistant Transport Officer. Lordship, have found it? My lord, I am Assistant Transport Officer, and the private respondent and the appellants are Assistant Research Officers. My lord, a strong argument was given that I am ex-cadre. But in the strength, my lord, if Lordship may see, if you see the first schedule on the first page, staff strength and skill, both gazetted and non-gazetted in Nagaland Legislative Assembly, my lord, it is clearly apparent. So, my lord, I'm now the whole trouble for the present respondent number 4 starts from second schedule, Lordship. Your Lordship may kindly see the second schedule. Post in the Legislative Secretariat, corresponding post in the Nagaland Government Service. Then Lordship may kindly see 11 with an asterisk, Assistant Protocol Officer, Lordship has found it, with an asterisk. Serial number 11. Second schedule, see row 16. The next, right after the first schedule.
Assistant Protocol Officer.
Yes, it is with serial number 11. With an asterisk. Lordship have found it? Then Lordship may kindly see 15. Assistant Transport Officer, Assistant Committee Officer, Assistant Research Officer is the appellant. Now Assistant Transport Officer with an asterisk. Assistant 16 with an asterisk. Librarian 17 with an asterisk. Receptionist. So serial number 11, 15, 16 and 17, Lordship. Lordship may kindly see the bottom in the next page. The next page on the bottom of that second schedule. Serial number 11, 15, 16 and 17, the incumbent in these categories will maintain your own cadre. Lordship has found that? My lady has found it?
Yes.
Now, in view of this asterisk, serial number schedule, second schedule, in view of the second schedule, this 4 posts, Assistant Protocol Officer, Assistant Transport Officer, Librarian and Receptionist, were kept outside the cadre of work. For the first time, kept outside the general cadre. Now we were kept outside the cadre. So, my lord, next page, the third schedule. This is the promotion channel for, this is the promotion channel. Now, my lord, Lordship may kindly see the serial number 7, Assistant Secretary, Assistant Committee Officer, Assistant Research Officer is there, UDA will be there. Now, those 4 posts were kept outside the general cadre, so were kept outside the channel of promotion. Even the UDA, Lordship, even an LDA, Lordship may kindly see the serial number 9. Even an LDA can go up to secretary. In fact, recently the joint secretaries who were promoted from LDA. So even from LDA secretary to LDA up to secretary, somebody will be promoted. But the 4 posts were kept outside the general gathering, were kept outside the general promotion. So, my lord, we were about, so, my lord, I was assistant transport officer. Then lordship mechanism is the next page. Chief editor, third schedule, lordship, chief editor. Lordship have found it. The next, thereafter, my lord, the next one. In the third schedule, It is continuation of the third schedule.
Chief editor.
Yes. So, my lord, the different wings in the assembly. So, my lord, the stenographers will go up to chief editor and then do general promotion. Then, my lord, lordship, you can go to the next page. Assistant protocol officer. Lordship have found it. So somebody in the protocol, only of the assistant protocol officer, then you retire there. Then lordship next, then lordship you can't see the last one. You'll find lordship will find assistant transport officer.
Sorry for the interruption, lordships. With regard to the caterer or not caterer, or whether there is promotional avenue or not, all these issues have been taken care of by WBC 323 of 2021. They have not challenged that. They have amended the service rule. Now, on the basis of the amended rule, they have taken some decision that is under challenge. And learned single judge has already given his verdict. Now, the grounds of challenge which you have taken, where the learned single judge has gone wrong, I have already placed my case. Let the respondent say that whatever decision has been given by the learned single judge is correct and it is sustainable. On that point, I think it will be reasonable because lordships are hearing a writ appeal, not a fresh petition. And the issue of this cadre has already been decided and they have not challenged that.
But not
Rather, instead of challenging, they have amended the rules.
the issue is this.
Otherwise, if on development all this,
The learned
Will be
counsel
learned.
has made a statement that I'm ex-cadre. I am not holding any substantive post. I am not holding any equivalent post. All those issues have been raised. So, my lord, how I was discriminated and how the rule was amended, I'm only highlighting the rules.
But that chapter is closed now.
if the respondents are
everything is
saying
amended.
that he is and she is in cadre, then let them show.
My lord,
In this manner, I am in the
Because-
cadre, eligible to be
because,
considered
my lord,
promotion. That
Because
is
now
the
by amendment of
relevant
civil
subject matter.
my lord, the point is, what I am highlighting now will have lordship will understand 323 judgment. Only if this rule is highlighted before lordship briefly. That's why I'm highlighting how the rule has been passed. Otherwise, there will be difficulty to appreciate the rules. So that is how we were kept outside. Then, my lord, first amendment of 2005 was brought by a notification dated 23rd of February 2005, lordship, it is flagged. Only the flag portion, lordship, make it say now I have already referred to the rules. I'll only First Amendment Rules 2005, which is flagged. Yes.
They all have flags.
Lordship, the first page, lordship, see first, on the first page, your lordship will say, First Amendment Rules 2005 incorporated in the first page.
First Amendment Rule, yes, 2005.
Just a reference, lordship, you kindly see at the flag portion on notification dated 23rd February 2005. I'll only refer the first line. The Speaker, lordship, a second amendment was brought by the Honorable Speaker in exercise of power under Rule 21, recitory powers. Just the notification, lordship, to see the rules. So the amendment was without legislative competence. Then, my lord, the second amendment, the second rules, the second amendment, my lord, second amendment rules 2012. There also, Lordship, you kindly see the flag portion. By 21st August 2012, in exercise of residuary powers under Rule 22, the Speaker had amended the rule without legislative competency. Just the flag portion. We did not put the other portions. So, my lord, in that view of the matter, the First Amendment and Second Amendment was declared void of an issue by a learned single judge in WBC 323. I'm coming to that. And so the First Amendment and Second Amendment is after rules is not holding the field. The original rules, principal rule of 1990 and the Third Amendment rules of 2022 is presently holding the field, and the First Amendment and Second Amendment, since it was enacted by the legislature, by the Honorable Speaker, in exercise of legislative power, not by the governor under 187.3, it was declared void of an issue in 323 WBC, that is why, my lord, I was pointing out, because a question you asked, what happens before this honorable court? What about the First Amendment and Second Amendment to the rule? That question may be right, may arise. That is why, my lord, I'm pointing out how the rules were enacted to appreciate. Now, my lord, so that is how the rules were amended. Now, my lord, I filed W315. My lord, I filed a writ petition, WBC 20 of 2021, and by an order dated 9/7/2021. My lord, this honorable court disposed of with a direction that my representation should be disposed of with a speaking order. Thereafter, lordship, the lordship may kindly go to page 80 and 81. My lord, at page 80, yes, the honorable speaker restructured the service rule in exercise of residuary powers. And lordship, the next page, the notification dated 1st November, the honorable speaker in exercise of residuary powers had recognized the private respondent in the general gathering. This was challenged in the next page, 323, lordship, by the association. That is page 82. Now, lordship may kindly see paragraph 6. Now, the question of constructive res judicata will come. My lord, this is a submission of my learned friend. In that case, my lord, the last 3 lines I'm writing, within a span of 25 years, the post of the respondent was upgraded for as many as 5 times in promotion was given to her against the upgraded post of making it personal to the incumbent. This was a submission, the same submission before another single judge in 323, paragraph 6. Now, my lord, the operative paragraphs is starting from 26. Paragraph 26, my lord, page 102. 26, my lord, 26, 27, lordship may kindly take note of the paragraphs. 26, 27, 29, 31, 32, 33, 34, 35. Now, the learned single judge, lordship may kindly see from paragraph 26, paragraphs 26 and 27, the First and Second Amendment, the learned single judge has come to the conclusion that the first and Second Amendment of the service rule was by the residuary power and without legislative competence. Page 29, paragraph 29, my lord, the restructuring by 1/11/2023 was without legislative competency. Then, my lord, 31, paragraph 31, my lord, the learned single judge has discussed Article 187.3. Then 32, my lord, Rule 22, residuary power under which the service was restructured. Then Lordship, may kindly allow me to read paragraph 34. In the state of Manipur versus such and such, the apex court held that an unconstitutional law created either due to lack of legislative competency or in violation of fundamental right guaranteed under Part 3 of the Constitution is void ab initio. So thereafter, Mandat 35, kindly allow me to read. Thereupon, due consideration in the matter in its entirety in the findings arrived at the preceding paragraphs, it cannot be said that the rights of the respondent has crystallized in any matter or that she had acquired vested right under the rules of 1966 or rules of 1999. Therefore, the Rajniki in G.S. Yadav are found to be not applicable to her case, and moreover, the facts of the circumstances involved are not similar. In the result, the enthroned orders are found to be unsustainable and hereby set aside. However, the same shall not depart the respondent authorities concerned from considering the restructuring of the various posts under Assembly Secretariat, which otherwise only to be done in accordance with relevant provisions of law, in the taking into consideration the rights and interests of all the stakeholders. Rights and interests of, after taking into consideration the rights and interests of all the rights, all of the rights and interests of all stakeholders includes everyone, Lordship. Thereafter, Lordship, the third amendment was notified, which is from 112 onwards. I'm not going through that. Then, Lordship, may kindly come to page 1. Now, page 122 is the my Lord Lordship may kindly see the petitioner number 2, page 122. The present appellant was also one of the petitioner here. Then, Lordship, here, Lordship may kindly paragraph 3 to 8 are the submissions of the counsel for the petitioner, my learned friend. Now, my Lord, can you allow me to read paragraph 7 and 8? What was his submission there? Page 127, 128. My Lord, I'm trying to prove constructive res judicata. The learned single judge also submitted, the learned senior counsel also submitted amended rules of 2022 has made the judgment in order dated 12/5/22 passed in 323 redundant and ineffective. He submits that the amendments was a repetition of the earlier office memorandum of 1/11/2022 and notification 1/11/2021, and which was set aside by the learned single judge. The learned senior counsel also submitted Rule 7P of the rules of 2022 is tailored made to suit the interests of certain individuals by inserting the word or equivalent in the Assembly Secretariat. It is submitted that this is not substantive post in the relevant service rule. Equivalent to the rank of additional secretary is said making the post of officer, except making the post of officer on special duty to speaker in the rank of additional secretary. The post of officer on special duty is to be filled up only by the stenos in terms of notification to the 6/11/2017, which also indicates that the said post is only meant for stenos bearing intertransferability of cadres. It submits the rules of 22 suffer from anomalies and discrepancies, and the official responses should have waived for the report of cadre review and service rules and amendments committee to arrive to funding. However, the respondent proceeded to amend the rules in a capricious and discreet manner, causing prejudice to the stakeholders. In their exercise of amending the rules is wholly arbitrary, illegal, and discriminatory in nature, and same was done without taking into consideration the right and the interests of all the stakeholders as the rightful and single judge. It is further submitted that Rule of 19 Rules of 2022 do not only keep the respondent number 3 to be a part of the general cadre in the rank of additional secretary, and by amending the third Schedule A has made the respondent number 3 eligible to be promoted to the post of secretary. By rules of 2022, rights of the petitioner to be considered promotion is clearly affected in as much as the public respondent number 3 is allowed to hold the post in the general cadre. Even though the status of his service is only ex-cadre in the same post, at the same time making her eligible to hold the post of additional secretary by virtue of her upgraded status as additional secretary. This is the submission, exactly the same submission he made yesterday. This prayer, this submissions, Lordship, my Lord learned friend has already come from paragraph 29 onwards is the merit discussed, which was read the other day. I'm not repeating it, but I'm only showing, Lordship, what was his stand in the earlier round of litigation. Now, Lordship is well aware that Lordship can become to 150. Now, Lordship, how the parties were born together. I'll briefly show the records, then I'll come to I'll show some other judgments. But now, Lordship, can you see 284? There was a general advertisement, assistant research on 20 December 1995, assistant research officer, assistant transfer officer, qualifications are all same. So we appeared for the same interview. And Lordship, we were thereafter, Lordship, you kindly see that page 70. Lordship, you kindly see page 76. My lord, this is the appointment orders of the appellant. My lord, which effect from 2nd September 1996. Now, Lordship, you kindly go to, my lord, 289. My lord, 289, 290 is a type copy. My lord, she submitted a representation on 3rd. She submitted a joining report dated 3rd September 1996 with a prayer that her joining report should be accepted retrospectively. And it was accepted. That's how 2nd September was given to her. Then, my lord, my order is 287. So we were 287, type copy is 288. So I am appointed from 3rd. Now, my lord, new merit list was published. When we were appointed in the same grade, new merit list was published. So no seniority was determined between the parties because Lordship, merit list is the basis to determine. In fact, I have been making a categorical statement from all along that merit list should be shown to us because according to my information, I'm more merit. I stood first in the exam, in the original interview. Now, my lord, Lordship, you can see Lordship 297, page 297. My lord, through RBI obtained the bookings. Lordship, you can see 297.
Yes.
It appears that when we move for creation of the 3 posts, that is assistant committee officer, assistant research officer, and assistant transport officer, we have not specified the nature and condition of the posts for which the posts are named to be rather general in nature, and according to the finance department has also conveyed their concurrence. The 3 posts are identical and carry the same status and scale of pay, hence it would be appropriate and also keep rooms for the office to assign capable person to man the post if all are treated in general matter. Therefore, however, the IRO and ATU are appointed in not necessarily mean the same post, but be intertransferable. Submitted. So, my lord, approved by the. So, my lord, initially there was only one cadre. All were treated as one. It was intertransferable. No distinction was made. I'm just trying to prove how I was discriminated when the Principal Act of 1990 was come and I was kept outside the general cadre for promotion. That's how, my lord, I submitted that representation. And on the basis of that representation, Lordship, the order was what which was set aside. Now, my lord, thereafter, Lordship is well aware that I was giving current charge. And after giving 155, 155 is the order by which I was given current charge. In exercise of power, under proviso to Rule 17, my lord, Lordship may kindly appreciate the fact that when the rule was subsequently amended first and second, Rule 17 was renumbered as 18. That's how 18 was used. Or 12 was renumbered as 12, 14 was renumbered as 15. Now, my lord, against this order of 5th July 2022, my lord, Lordship, a writ petition 144 is filed, and by 22/7/2022, Lordship, interim order was granted. Lordship may kindly take note of paragraph 4. To save time, I will not read this, but Lordship may kindly take note of this. What was the submission of the learned counsel for the petitioner at page 160? 160. The submission of the same submissions was given and interim order was granted, which is in paragraph 12 at page 164. That I am not eligible and she is the senior most. And I am holding ex category. These are the submissions. Same submissions which he has been made. Now, my lord, 165. My lord, against the interim order, I filed IA 1116 of 2027. Now, my lord, when order dated 12/8/2022, the interim order was vacated by a single judge. Now, Lordship, you kindly allow me at paragraph 2, page 167, before the second paragraph, before I go further, the facts and circumstances leading to filing of the writ petition in this IA is briefly stated as follows. Then serial number Roman 1, 2, 3, 4, 5, 6, up to 6, my lord, the learned single judge had taken the great pain to narrate all the facts properly in chronological order. Lordship, you kindly take note of it. To save time, I'm not reading it. But once paragraph 2, Roman 1 to 6 is perused, my lord, the whole facts will be given in detail. Lordship will not go to search for other facts. Everything is narrated by learned single judge in chronological orders. Then, Lordship, I am jumping to paragraph 5, page 177. Mr. C.D. Jabir, counsel appearing for the opposite party, who is the petitioner in the connected writ petition submitted at the outset, the applicant, as per rules of 1992, amended from time to time, is not eligible for the post of secretary to the Nagaland Legislative Assembly, but was made eligible only by the latest amendment, which is under challenge in 92/2022. See, so it was by his own submission, he is admitting that I'm eligible. Therefore, till such time the writ petition challenging the rule is disposed, he can neither be considered for regular appointment nor for temporary appointment to the post of secretary in Nagaland Legislative Assembly Secretariat, even for holding current charge of the same, especially when there are other people who have been eligible for appointment to the post as per the rules that has been in existence. Secondly, Chamber submitted that the giving of charge, though temporary it may be, should be the senior most officer of the Nagaland Legislative Assembly, completed in Rule 18 of the Nagaland Legislative Assembly, amended from time to time. By referring to the rule, the learned single judge, senior counsel further submitted the word senior most, make it amply clear that it should be none other than the senior most in the secretariat who should be given charge of the secretariat. Then, Lordship, paragraph 6. Can you allow me to read the rest? It appears from the ensuing order and submission of learned counsel of the parties, the applicant was given only current charge of secretary in the exigency of service till the disposal of the PPC 92, which is pending before this court without bestowing any benefit. Rule 18 of the Nagaland legislation, which has remained as such, empowers the speaker to appoint or to give charge of secretary in any of the senior most officers.
As can be seen, the word any appearing in the second paragraph of the rule precedes the word senior most. Therefore, reading of the whole rule would mean that the honorable speaker can delegate the charge of any of the office to any of the senior most officer in the secretariat. The applicant being one of the senior most is therefore eligible for holding the temporary charge of the secretary as per the provisions of the rules. As such, I am of the view that the honorable speaker, while representing the discretionary power, has not committed any illegality which violates the right of anybody. Further, there is nothing in the record to show that the opposite party number one, as claimed by her, is the senior most in the assembly secretariat, and seniority among the officers, especially in the rank of additional secretary, has been determined. Though it is true that the initial appointment order showed that the applicant was appointed 1 day earlier, later than the opposite number one, the seniority between them has not been determined so far. Therefore, the claim of the opposite party number one that she is the senior most in the assembly secretary cannot be accepted as gospel truth at this juncture. The third amendment, which is under challenge, has no doubt reorganized the service of the employees of the assembly secretary, especially from joint secretary to secretary, and has brought the service of the applicant in a general category and has made her eligible for promotion to the post of secretary. Is to be appointed by the governor under recommendation of the speaker in consultation with the chief minister as per clause B7B of the amended rules. The post of secretary is to be filled up by promotion from the grade of additional secretary or equivalent in the assembly secretary with a minimum of 2 years continuous service in the grade if deemed by the appointing authority. The word if deemed fit by the appointing authority makes it amply clear that the promotion to the post of assembly secretary is by selection, not by seniority. Therefore, the delegation of charge of the secretary to any of the senior most will depend on their seniority. Taking into view the facts and circumstances of the relevant rules, it appears that the interim order was passed due to non-misrepresentation of the relevant rules and the facts and circumstances properly. Therefore, in my considered view, the continuation, then it was vacated. Then motion, you can see the next page. You read the bill was filed. Now, my lord, I'm reading from paragraph 7, page 184. Very lordship. Mr. Chairman, when the senior counsel submitted the petitioner is senior to the prior respondent in the service, and her appointment is in the general matter of the service, where can one can be promoted to the post of secretary. As for the prior respondent, she is appointed as assistant transport officer in a particular category and was subsequently by way of accreditation upgraded to the level of and as additional secretary transport. He submits before the rules 2002 comes into force. The private respondent was not eligible to be considered for promotion to the post of secretary in LA, as the rules of 2022 were challenged by the petitioner and others in WPC 92. The private respondent could not have been delegated a temporary official in charge of the post of secretary by ignoring the petitioner. He submitted an Indian order dated 5/7/2022. Is said to have been passed in accordance with Rule 18 of the rules of 1999 as amended, and appear perusal of the 18 only goes to show that senior most officer is to be given preference. Paragraph 8. Council referring to Indian order submitted interpretation of Rule 18 given by the single judge cannot be said to be correct interpretation. He submitted when the single judge has stressed upon the word in coming to the conclusion to forget the interim order. Therefore, what has been considered as the word senior most going by the entering into service, the petitioner immediately is the senior most. 9. There's further submits that was heard and reserved for the judgment. Then, my lord, my submissions. Then, my lord, paragraph 14. The operating paragraphs are from 13, but I'll read 14, lordship. 14 and 15. We have noticed that when the interim order dated 22/7/2022 was passed, and subsequently the order of vacation of the interim order passed in 18/12/2022, the ordered petition for the petitioner challenging has not been decided. The recited petition was consequently heard and dismissed by an coordinate bench of the Vice Judgment 24/4/2024. No material has been placed before us about any further appeal or review being preferred by the said aggrieved by the party aggrieved, and therefore admittedly the position is that the rule of 2022 subsists. Having regard the relevant provisions of rules of 2022 for the filling up of the post of NLA, it can be seen that as on today, the petitioner as well as the private respondents who are the contesting parties are eligible to be considered for the post. The said post admittedly could not have been filled up on regular basis during the pendency of WPC 9 of 22 of 2022 in view of the challenge rules of 2022. Therefore, to dwell upon the interpretation of rule will be an exercise, it will be an academic exercise. Then 18th, we are therefore of the considered view that having regard to temporary arrangement being made in the same at the same time, the importance and necessity of being the posts to be met substantively by an eligible and qualified person as per the provisions of the rule, we are inclined to interfere with the Indian. We are not inclined to interfere with the Indian Order till 12/8/2022. However, we have to consider the view that there should be no further delay in filling up the posts in regular basis in accordance with law. So, my lord, constructive res judicata squarely applies in the present case. That is what I'm trying to highlight before this honorable court. Then notice next page, 194. Now, 92, now in view of that, on 5/9/2024, the PPC 144 was withdrawn by the writ petition. Page 193, 194. Now, my lord, 1202, that is the Indian order, which is challenged. My lord, Roshini Kalisi, Kali allow me to read this, page 1202. In superstition of the Secretariat order interpreted such and such in the interest of public service, the governor of Nagaland is pleased to promote Ryu to the post of Secretary, Nagaland Assembly, in all other allowances as are admissible under the rules from the time with effect from 5/7/2022. My lord, the 5/7/2022 is the date on which I was given current charge. 202, Lordship. Now, my lord, that effective date of 5/7/2022, by the date on which I was given current charge, was challenged by them in the earlier round of litigation with going up to division bench in 144 was ultimately withdrawn. So in that view of the matter, the appointing authority may treat that my seniority should come with effect from 5/7/2022. So it is not a retrospective regularization or retrospective promotion, because I was serving from that time onwards. And the eligibility has been already determined. So, my lord, these are the situations. These are the situation under which, my lord, I was given promotion and promoted. I was considered and promoted. Now, my lord, non-jointer eligibility of the petitioner is already decided, so I'm not repeating all that. Then constructive res judicata, my lord, I have already decided, my lord, highlighted. Now, my lord, just to substantiate the point, on Rule 14, Rule 12, Rule 14 and 15, just to substantiate quickly the submission of my respondent for counsel for respondent number 1, 2, and 3. Lordship, the principal rules, I'll quickly refer to these rules to make a comparison. The principal rule of 1990, principal rule of 1990, sorry, 1999, I'm sorry, 1999, Rule 11, appointing authority. Now, the secretary shall be appointed by the governor in consultation with the speaker, and all 11(2) appointment to all other posts shall be made by the speaker. So, my lord, two categories. I'm only substantiating what my learned friend has submitted, just as a reminder, lordship. Two categories. Secretary, one category, and up to rank of additional secretary, another category. The first category to be appointed by the governor, and lordship, the second category up to the grade of additional secretary under which comes under 11.2 will be by TPC under Rule 40. Now, my lord, therefore, lordship, you kindly come to Rule 22. Rule 22, interpretation. Subject to the provision of these rules, all questions relating to interpretation of these rules shall be referred to the speaker, whose decision shall be final. So which rule to be applied? Either Rule 11 or Rule 14 in the principal rule. Which to be applied? It requires an interpretation. And my lord, top powers lies with the Honorable Speaker under Rule 22, which is final, and the Honorable Speaker has already interpreted the rules that for the post of Secretary under Rule 12, 11.1. Now, my lord, a very important submission, strenuous submission was given by my learned friend that under Schedule 3, of the principal rule, since I'm kept outside the room, gathered, and he has made a submission that no, lordship may kindly appreciate the fact that in view of Schedule 2, where I'm kept outside the gather, Schedule 3 is not made up, is not made up, is not applicable to me. Was not made applicable to me because, my lord, I am kept outside of Schedule 3, C routine, by the asterisks in Schedule 2. My lord, Schedule 3 is the channel of promotion. Now, by asterisks in Schedule 2, I'm kept outside the Schedule 3, so Schedule 3 is not applicable to me. The original principle Schedule 3 is not applicable to me because I'm kept outside of this schedule. Now, my lord, my learned friend has made a submission yesterday that an order was required. He made a specific submission that no order has been issued by the competent authority to show that our posts are equivalent. No order has been issued by the competent authority bringing the preferred respondent for into the general gather. In that view of the matter, I am still outside the gather. That was the argument given by him yesterday. What I'm trying to submit, lordship, is lordship schedule in the original rule of Schedule 3, I was kept outside the gather. I was kept outside the promotional channel. Now, the operation of law, when the rule was amended to the third amendment, 18 May 2022, by the operation of law, the distinction has been removed. Distinction has been removed. My lord, can you see Rule 10, the amended Rule 10? Streamlining of existing gather, that there shall be no interest up to the grant of Joint Secretary and no distinction of gather up to and shall can you allow me to read Rule 4? See Rule 10, streamlining of existing gather. The existing clause A and B are replaced with farming. There shall be no intertransferability from the gather schedules of the rank of Joint Secretary. There shall be no distinction of gather about the level of Joint Secretary in the assignment of duty distribution of work for all other services service matters. So, my lord, by this operation of law, I become entitled and no specific is necessary to show equivalence or lordship to show that I am in gather, because the question of gather, the distinction of gather is abolished after beyond the level of Joint Secretary. So nobody is required, so his submission is without any valid substance. That is what I'm trying to highlight to lordship and lordship. Lordship may kindly compare the third schedule in the principal rule and third schedule in the amended rules. I am coming to the concluding part. In the first schedule, Lordship, in the third schedule for promotion to the post of secretary, Lordship, but in the third schedule, Lordship, in the principal rules. If Lordship may kindly compare the two. In the principal rule, by promotion from additional secretary with minimum of 2 years continuous service in the grade or class may be 10 feet. That is the principal rule. Then Lordship may compare with the third schedule, the amended. By promotion from the grade of additional secretary and the or equivalent is added. Or equivalent is added in the assembly secretariat with a minimum of 2 years continuous service in the grade, Lordship, then the or is deleted. And as may be 10 feet is changed into 15 feet by the authority. So, my lord, as may be 10 feet is now 15 feet by the authority, as is replaced by the word if. If 10 feet by the operating authority, as may be 10 feet, but the word operating authority was absent in the principal rule. Not the word operating authority is in the amended rules. As 10 feet only, or as maybe 10 feet only. Now the is 10 feet by the appointing authority. So that is the changes. Lordship may kindly appreciate that. Now, my lord, I'll only quickly place some judgments and I'll be concluding thereafter. Lordship, first judgment is 2026, 2 SCC 779, paragraph 16, Lordship, 16 and 17, Lordship, on non-joinder of necessary party. Lordship, kindly allow me, paragraph 16, I'll kindly come to go to the last page to save time.
Which judgment you are referring to?
First one, Unam versus Sita Bhotra.
Oh, yes.
Now, Lordship, the last page. My lord, I have marked it E. Therefore, the proposition that can safely be called cult out is that the authorities or the tribunals who in law are entitled to defend the orders passed by them are necessary parties, and if they are not arrayed as parties, the writ petition can be treated as non-mutable, or as the court may grant liberty to inflict them as parties in the exercise of discretion. There are tribunals which are not required to defend their own order. In that case, such tribunal need not be arrayed as parties. The principle that has been called out in the said case is that tribunal or defending authorities would only become a necessary party which is entitled in the order. The term entitled to defend confers an inherent right to a person if he or she is affected or is likely to be affected by the order or to be passed by any legal forum or for there would be violation of natural justice. The principle of alteram partem has its own sanctity, but the principle of natural justice is not always put in a straitjacket formula. That apart, a person or an authority must have a legal right or right in law to defend or assist. Secondly, Lordship, Shift Gender Moore and others, Lieutenant Governor, 2014-11 HC 744, paragraph 23. On res judicata.
Mission, this Ranbir Singh.
No, shift gender more.
Oh, yes.
My lord, paragraph 23. Reference has been made by the Constitution Bench in the Recruit Engineers State of Maharashtra, where this court once again reiterated that principle of constructive res judicata applied not only in what is actually adjudicated or determined in a case, but every other matter which parties might or and ought to have litigated and which was incidental to or essentially connected with the subject matter of the litigation. 30, Lordship. Ranbir Singh. 2011-15 SEC 453, Lordship. I'm relying on, my lord, paragraph 5 and 6. We are written. Before us today, the Learners' Council for the Appellant has argued that in the writ petition filed the respondent stage, challenging the award of labor court, the only play was made against the ground of fact, which is nothing more in support of his submission. The Learners' Council has drawn our attention to the writ petition, which has been submitted with the paper book. We find that the assertion of the Learners' Council is correct. We are therefore of the opinion that the order of the Learners' Single Judge, as well as the division bench of the High Court, was well beyond the scope of the prayers of the writ petition. If the state feel aggrieved by the award of the labor court in total, there was no impediment on its way to challenge it in its entirety. We feel, this is important, my lord, we feel that the party must be bound by its pleadings. A prayer clause cannot be construed or dubbed as a technicality. We are therefore of the opinion that the appeal deserves to succeed. Parties are bound by their pleadings. I'm referring specifically to paragraph 21 of the writ petition. And, Lordship, court prayer and a prayer clause cannot be construed. Because, Lordship, I made a submission that we have abandoned the prayers. Then, my lord, the next case, the thick one, the UP Junior High School, paragraph 45. Just for Lordship, on question of substantive post. Paragraph 45. Near it. Paragraph 45. In this instant case, all the appointments of instructors were made by following the procedure prescribed under the scheme pursuant to a proper advertisement. In essence, they are all substantively appointed. Maybe there were no sanction posts, but the sanction of post is deemed to be there as the nature of the work assigned to this instructors. Teachers is of a permanent nature, which in all probabilities is of a continuing nature and is not likely to be abandoned or curtailed in any manner. The term substantive appointment is not so defined, but in service jurisprudence is considered to mean an appointment, not being an ad hoc appointment on a post made after selection in accordance with the rules and in the absence of the rules in accordance with the procedure prescribed for under any scheme or instruction of the government. Therefore, once this instructors had undergone the process of election under the scheme, regardless of the fact that there exists a post, their appointment have to be treated as substantive in character. Finally, Lordship, to substantiate on the Kalyan Tumbi Valley Municipal Corporation, my lord, on the harmonious interpretation of rules from rule 30, paragraph 30 to Lordship 33. Paragraph 30 to 33. Yeah, right, Lordship. In Phillips India versus Labour Courts, this court has occasion to decide the rate of overtime wages as mentioned in section 331 of the Tamil Nadu Shops and Establishment Act 1947. This court found that for finding the minimum wage of overtime wages as mentioned in section 31 of the said act, it will have to be interpreted in the light of the provisions contained in the section 14(1) with the proviso to section 31 of the said act. Coming to this conclusion, this court observed thus: no canon or statutory construction is more likely established than the statute must be read as a whole. This is a general rule of construction applicable to all statutes alike, which is spoken of as construction ex vesi repas actus, that is, from the mere words and nothing else. This rule of statutory construction is so firmly established that it is variously styled as elementary rule and as a settled rule. The only recognized exception to this rule with late principle is that it cannot be called in aid to alter the meaning of what is of itself clear and explicit. Lord Coke laid down that it is the most natural and genuine exposition of a statute to construe one part of a statute by another part of the same statute for the best expression meaning of the makers. It would be thus seen that this court has held that statute must be read as a whole. It has been held that this rule of statutory construction is so firmly established that it is variously styled as elementary rule. It has been held that for finding out the true meaning of one part of the statute, a reference will have to be made to another part of the statute, and that will best express meaning of the makers. In such and such, this court was considering a question regarding conflict under Rule Section 67 of CPC and Order 21 of the Rule 2. This court has held that applying the rule of harmonious construction, the so-called conflict between the said two provisions has been dispelled. Observing so, this court reiterated the following well-settled principles of interpretation of statutes. On the conspectus of the case law indicated above, the following principles are clearly discernible. 1. It is the duty of the courts to avoid head and clash between two sections of the Act and to construe the provisions which appear to be in conflict with each other in such a manner as to harmonize them. 2. The provision of one section of the statute cannot be used to defeat the other provision unless the court is in spite of its faults, find it impossible to effect reconciliation between the three. It has to be borne in mind that by all the courts all the time, that when there are two conflicting provisions in the Act which cannot be reconciled with each other, they shall be interpreted that if possible, effect should be given to both. This is the essence of rule of harmonious construction. The court had also to keep in mind that interpretation which reduces one of the provision as a dead letter or useless number is not harmonious construction. 5. To harmonize is not to destroy any statutory provision or to render it authorized. 33. It has been seen that this court has held that it is the duty of the court to avoid head and clash between two sections of the Act and to construe the provision which appears to be in conflict with each other in such a manner so as to harmonize them. It has been further held that the provisions of one section of the statute cannot be used to defeat the other provisions unless the court finds a reconciliation between them impossible. It has further been held that when two conflicting provisions in an Act cannot be reconciled with each other, it should be interpreted that if possible, effect will be given to both. It has further been held that interpretation which reduces one of the provision as dead letter or useless number should be avoided. So, my lord, if EPC, so my lord, the application of Rule 14 renumbered as 15 and application of Rule 11 renumbered as 12, keeping in mind that Rule 11 in the principal rule have two provisions, one for secretary and additional secretary, and the rest of the joint secretary is covered by Rule 12.2. So it is clear distinction has been made from there, and it has and the clear route which way to go it has been provided. So, my lord, there's no, and if we go by the interpretation submitted by the learned counsel for appellant, then Rule 12.1 will become dead. It will become redundant. Now, my lord, the other day, my learned friend, learned counsel for respondent number 1, 2, and 3, has referred to 225.7 GLD 501. When two views are possible, then the views taken by the learned single judge will take precedence before the appellate court. That is the law laid down. And unless in intra-court appeal, Lordship 220/16 SCC 478 has been referred to. So in that view of the matter, Lordship, the learned single judge, taking into consideration the manner in which I was born together, how people in the different branches were discriminated by the principal amendment to the rules of 1999, in keeping that in mind, my lord, The rule was amended in the year 2022 so that justice is served. Now, presently, Lordship, there are different wings in the assembly. So, from different wings, after the joint secretary, they come in their own wings. And thereafter, without any distinction from the grade of additional secretaries, because Lordship, from additional secretary onwards, it is only administrative in nature. So, that way, everyone become eligible without any distinction. Distinction of cadre is still joint secretary. So, in that view of the matter, Lordship, now, besides the petitioner, the respondent number 4, who is from the transport wing, people from the library wing, people from the Malot steno, and people from the legislative wings also are now become eligible for promotion to the post of additional secretary and secretary. Now there's a level playing field for everyone without any discrimination and distinction. Just because I'm promoted does not mean that Malot others are also not eligible, because now what is happening is I am from transport wing. Tomorrow, if eligible, anybody from the other wings other than the general administrative wing become eligible. So what is wrong? What is in that, keeping that in mind, and in view of the series of litigations that has taken place in the judgment that has been passed, the learned single judge has rightly come to a conclusion and dismissed the writ petition. So in that view of the matter, Lordship, I find no infirmity, no irregularity in the impugned judgment. And Lordship, the present writ appeal is devoid of merit and it should be dismissed. Much obliged, Lordship.
Okay, your reply.
Combining what the councils, they have taken about little more than 3 hours, but I will try to cover up within 15 minutes time, Lordships. Some points are common for respondent number 1, 2, and 3, and 4. They are all common. In some areas, they are different. And I would like to reply some points in common and others differently. Firstly, Lordships, both the learned councils have referred to page 68 of the appeal memo, especially paragraph 21, where there is a statement that in the writ petition, respondent number 4 became eligible to be considered with effect from 18/5/2022. That is the date when the rule came into force. That is the Third Amendment rules. Now, on that point, it is with regard to the eligibility, whether she is eligible or not. Whether, if I say that she is eligible, or for that matter, if anybody says that she is not eligible, whether eligible or not, whether that is a question of law or question of fact, I'm submitting that whether she is eligible or not under the rules is a question of law. When it is a question of law, even if in the pleading the council submit that it is like this, if it is contrary to the law, that will not be accepted, that cannot be taken. But question of fact, if I make some submission, if I make some concession or statement on the facts, that will be accepted. And I cannot go back. That should be accepted as correct. But on the question of law, even if I say, and even if I mention in the pleading, that will not be accepted. Because the issue of eligibility is a question of law. Therefore, even if there is a statement to the effect that respondent number 4 became eligible with effect from 18/5/2022, may not be accepted if the law doesn't permit that. So there can be no stoppage against law. Lordships are well aware. When it is a question of law, there can be no stoppage. Even if I submit, even if somebody says, that will not be accepted under question of law. It has to go as per the law, what the law says. And in this particular case, the division bench, while deciding writ appeal 28 of 2022, has categorically stated that with regard to the filling of the post of secretary, there should be no delay and the same should be done in accordance with law. So what the law says will be relevant, not that what I say, what he says, or for that matter, anybody says. So I have one case in that connection. Admission of fact by the council are binding. Admission of fact by the council are binding. Neither the client nor the court is bound by admission as to matters of law or legal conclusions. If it is a question of law and legal conclusions, then that will not be again. So far as eligibility is concerned, it is a question of law. Therefore, no stupid against law. That will be applicable, and I'm citing the judgment 2022 11 SCC. 2022 11 SCC 392. Relevant paragraphs are paragraph 23 to 26. Let me not read the judgment. I'm just quoting the paragraph 23 to 26. Paragraphs are short. So this is on the point that admission of fact by counsel are binding.
Paragraph 23 and
23 to
23 to 26. Admission of fact by counsel are binding. Neither the client nor the court is bound by admissions as to matters of law or legal conclusions. And another point may be taken that there can be no stobble against law. Now, let me come to the submission of the counsel for the respondent number 1, 2, and 3. His second point was Rule 12 to be read with third schedule. And by reading these two, Rule 12 and third schedule, A, it does not say that the post should be substantive, because I was making submission that the respondent number 4 should be holding a substantive post. Now, third amendment has only added one word, that is, or equivalent grade. Third amendment has added in the schedule. Now, to check whether she is equivalent or not, a person should be holding a regular sanctioned post in terms of the provisions of the service rule. Then only one can be tried at bar. So far as respondent number 4 is concerned, let them show that in terms of the provisions of the service rule, this is a sanctioned post, this is a substantive post, I'm holding this post. Other than the transport officer. About that, let the respondent show, because all posts are upgraded, which are not in the service rule. Therefore, she was holding a post outside. Therefore, she was not holding a substantive post. Therefore, she cannot be equated with me and it cannot be equivalent. Therefore, the question and issue of consideration of her case does not arise. It should be a substantive post under the provisions of the service rule. And the relevant two service rules are 1999 rules and the third amendment of 2022. these are the rules which are governing the service conditions of all the employees. There is no provision in the service rule that the post of secretary should be not governed by the service rule. She is governed by the service rule. Her post comes within the provisions of the service rule. That is why in the schedule, the post of secretary is also shown. In what manner it has to be filled up, it is also prescribed. So it has to be done as per the provisions of the service law. Third point. With regard to the substantive capacity, appointment must be in a substantive capacity. On that point, I have a judgment. And the counsel for the respondent has made a submission that the substantive appointment accreditation can also be treated as holding a substantive post. To some extent, he is correct. To what extent he is correct? If there is a selection and the post has been upgraded to a higher post, giving opportunity to all others, then it can be treated as a promotion. Even the upgradation. Under some situation, upgradation can be treated as a promotion when the upgradation has been done on the basis of some selection. Then, in that case, it can also be treated as a promotion. To that extent, whatever the learned counsel has submitted is correct and the judgment which he has shown is correct, but there has to be a selection process. Even for the upgradation, then it can be treated as holding a substantive post. Otherwise, not. Therefore, the appointment must be in a substantive post. And if selection, upgradation is done on the basis of a selection process, yes, it can be treated as a promotion. But her upgradation all along was personal to the incumbent. Therefore, it cannot be treated as a promotion. Therefore, her last promotion was up to the post of transport officer in accordance with law. Others were all upgradation personal to the incumbent. And when she was holding a post personal to the incumbent, she was given the current charge and that was regularized initially, thereafter promoted. So I have a judgment in that. Appointment must be in a substantive capacity, that is 2021 12 ACC 127. I will refer only one paragraph, that is paragraph 14. 2021 12 ACC 127, paragraph 4. Institute of Chartered Accountant of India versus is paragraph 14. Let me not read that. If your lordship permits, then may I go to the second point, next point again?
Yes.
The third point which the learned counsel has submitted was DBC under Rule 15 is not for the post of secretary. On this point, I just want to give a one-line reply that by reading Rule 15, for all cases of promotions and selection, constitution of DBC, secretary is also included here. Therefore, that submission is contrary to what the rule says. And rule do not say that the post of secretary is excluded from the purview of DBC. Nowhere in the entire rule it is mentioned that the post of, while promoting the post of, considering the post of secretary, DBC shall not be constituted. There is no provision in the service law to that effect. it is only their submission that no, secretary, TVC is not applicable for the post of secretary. It is their own creation. And the learned single judge was convinced by that. Otherwise, service rule doesn't say that. Another point, and the same post, that is in the post of secretary, the learned council has made a submission that the post of secretary is a selection post and not a promotional post. Lordship will remember, Lordship can also see at page 202, that is the MBO order, that is 25/3/2026. What is mentioned in the order itself, whether it is a promotion or appointment. It is a promotion. In the promotion order, in the promotion order itself, and the submission is making that the post of secretary is a selection post, not a promotional post. So this submission is contrary to the rules in the schedule, how the secretary should be filled up. That is shown already in the third schedule A, that from the additional secretary by promotion, who has served for 2 years of continuous service. That is there in the rules. So that submission is contrary to the rules. On their own admission, they have defeated by saying that the post of secretary is a selection post and not a promotion post. But the MBO order itself is a promotion order, not an appointment, which only demonstrates that the action of the respondents is whimsical and arbitrary without based on any reasons, justified reasons. Records have been produced during the course of hearing to justify the MBO order dated 25/3/2026. Earlier, prior to this order, there was another order, that is 9/3/2026, by which the respondent number 4 was regularized. Even on that day also, they were ready, they were so curious and anxious to produce the record. We have the record, we will show the record. Nothing prevents that. They want to show the record. And while reading out the records, a portion of the records, it was revealed that both petitioner, the appellant, and the respondent number 4 were considered. That is what I have learned while reading. If they have considered the cases under which provisions of the service rule they have considered whether the procedure adopted by them, as is mentioned in the record, is in accordance with the provisions of the service rule or not. That may be examined, since records are before Lordship. And the process was initiated for regularization, which was culminated by issuing an order on 9/3/2026. Then, whether there was another fresh process for the case of promotion to be issued on 25/3/2026, or the same process which was initiated for the case of regularization, basing on that only, they have issued the promotion order also. So that aspect may be considered by the Honorable Court, since records are before an Honorable Court. Whether a separate process was done for regularization as well as for promotion. And if it is only one process, then definitely it is not in accordance with law. And whether the procedure adopted by them for promotion or for regularization, whether it has been done in accordance with the provisions of the service rule or not, that may kindly be examined. Now, let me come to the submission of my learned friend, the counsel for the respondent number 4. He has referred to the same paragraph, that is page 68, paragraph 21, which I have already covered. I will not repeat. Next point was on page 48, paragraph 35, to show the prayer made by the petitioner appellant. And to show that he has referred to the prayer made in the writ appeal and the prayer made in the writ petition, that only a general prayer was made in the writ appeal. But lordships are well aware that once the Indian order of learned single judge is set aside and quashed, everything goes. And if there is an order allowing the writ petition, then the original prayer which has been made in the writ petition will reveal. Therefore, it is not a substantive submission to be considered. And in order to support that, he has referred to Order 7, Rule 7. Lordship, may kindly have a look of Order 7, Rule 7. It talks about the pleadings and prayers made in the plain, not in a writ petition. And lordships are hearing the writ petition and the writ appeal under Article 226 of the Constitution of India. So that argument based on Order 7, Rule 7 is irrelevant so far as we are concerned. The next submission was made that the Indian judgment has been passed on the basis of so many proceedings which has taken place. And let me combine two aspects here. The counsel for the respondent number 4 has also referred to a writ petition which was filed in 2021, writ petition number 20 of 2021, where the order was passed to dispose of her representation, and her representation was considered. Accordingly, orders were issued, that is 1st November 2021. Both the orders were quashed in WPC 323 of 2021 by judgment and order dated 12/5/2022. Therefore, these are all decided already. So, whether her earlier background was brought in while passing the Indian order or not, Indian judgment and order or not, those are irrelevant because WPC 323 has up 21 has already taken care all these aspects. Now, another point was on the issue of Speaker passed the order based on my representation. That is already covered because that is already answered in 323 of 2021. And they have not challenged this order. Most importantly, they have not challenged this order of 12/5/2022 order, which was passed in 323 of 2021. They have not challenged. But instead of challenging that, they have amended the rules. And the grievance has been raised by the counsel for the respondent number 4 that, look, I have raised the preliminary objection on this point, and this point, and this point, non-gender of parties and all these things. And the learned single judge has not decided this, and no finding is arrived on it. If they are aggrieved by the order of the learned single judge, then they could have challenged. They have not challenged that. So in this later today, they cannot question and beat around the bush and all these irrelevant points, lordships. Now, on the issue of preliminary objection, another important point which, according to them, has been raised, that is the non-joinder of necessary party. In that context, I would just like to refer to Article 361 of the Constitution of India. Their exemption has been granted to paragraph clause 1, and the proviso will be very clear. Governors are not required to make parties. And lordships are aware. Even Lordship, my lord, Justice Saikia will remember the case about the appointment of chairman of Assam Public Service Commissions. Appointing authority is the governor, but in none of the litigations, the governor has been made as party also. So this are not relevant so as to decide this subject matter, lordships. Governor and chief ministers cannot be made parties. These are unnecessary. Of course, my learned friend has made a reference that he has advised the petitioners, pointed out by filing the objection that they should be made party, but we have not listened to. I don't want to listen to all the advices, whatever is coming. So we have not listened, but then we thought it appropriate that we have to go as per the provisions of law. So they were not made parties. See Secretary, and then another next point. The ATO and TO, that is Assistant Transport Officer and the Transport Officer, are shown in the cadre in the earlier service rules, and they were shown as one. That was the condition, but later on it was removed. And then subsequently the third amendment came. Now, earlier, prior to 1999 rules, they were in the same grade, maybe fine. But initial appointment and subsequent developments are totally different. I may be senior in the lower grade. In the higher grade, I may be senior. There may be some selection process, qualifying examinations, I may fail, I may clear earlier than the others. So like that. Since you're in the cadre in the initial stage, doesn't mean that you will always be remain in the cadre. But anyway, all these points have been taken care of by this Honorable Court in WBC 323 of 2021. All these points have been discussed. Who are in the cadre, who should be in the cadre, who should not be cadre, all this have been discussed, and this judgment they have not challenged. Rather, they have resorted to amend the rules. So by amendment, whether the right has been conferred or not, since yesterday I have been making this submission again and again, because this is the moot point where this Honorable Court has to decide. And if the third amendment of 2022 has conferred any right to the petitioner, let them show clearly that, look, by these provisions, I have been brought to the cadre, and now I'm equivalent with so-and-so, and I can be considered for the post of secretary. As of now, they have not able to demonstrate that. They have not shown anything on that. Therefore, the claim is made on the basis of an arbitrary, whimsical, and illegal decision of the respondent authorities. Now,
the Assembly Secretary, they don't maintain seniority list. They don't maintain seniority list.
they maintain. I can also show.
Separate wings.
After some time, I will place. It is there, but I will place the seniority also, because then a single judge has arrived to a conclusion that is on the basis of the submission made by the counsel for the respondent number 4. Till today, seniority has not been determined. Therefore, how can the petitioner, claim that she is the senior most? That is without any basis. That was the submission. Basing on that submission, the learned single judge has arrived to a conclusion, finding that seniority has not been determined yet. But it is contrary to the records. But that was not an issue in the case. That's why there was no occasion for us to also argue on that and to bring that because it is not on that issue. The issue of seniority was not discussed.
In any case, if it is decided that it's a selection post, then seniority does not matter, of course.
Yes. But in order to be in the selection, who are persons to be considered? That is important. Because selection, the word selection is, for the post of secretary, there are 4 channels of appointment. Number 1, that is by promotion. 2, by deputation from another department. By direct recruitment. Any person can be recruited directly. Non-member of assembly secretary.
Even judicial officers have gone.
And then short-term contractual appointment. So except 1, that is by promotion. 3 are selection. It will be done by selection. For them, DBC is not required. Rule has not clearly defined all these things. But for these 3 channel of appointment, there can be selection. Direct appointment. Because they are not promoted. But the MBO notary itself is a promotion, which is clearly specified in the service rule. They are bringing on Rule 12 that look, procedure has been changed. This has to be done only in this. But it is a promotion. Your own order speaks that. And in order to consider her case for selection, she should be holding a substantive post. Her position is only upgradation. Should I switch over to the next point?
Yes.
Next point is on the current judge order dated 5/7/2022 was challenged by the petitioner and withdrawn by order dated withdrawn the writ petition, challenge to the current charge. But then ultimately the division bench has decided this in the writ appeal 28/2022. And the last part of the judgment, Lordship will find that fill up the post of secretary without delay in accordance with law. It has never decided who should be considered, who should not be considered. Because the challenge was on the current charge, temporary current charge. Even for temporary current charge, it should have been given to the senior most, but why you have given to others? That was the case. And the writ appeal was on a temporary interim order, against the interim order. There, since it is only for temporary charge, okay, we are not interfering. But for regular basis, you fill up the post in accordance with law. So what the law says will come again. And if the current charge is the basis of promotion of the respondent number 4, suppose if the current charge is given to the petitioner also, then can it be the basis to promote and to allow to regularize or to promote to the next higher post? That cannot be. Current charge can be given to anybody. But for filling up the post on regular basis, it has to be done in accordance with law. I am not disputing the power of the speaker. He has the discretion, he has the power to run the office. Therefore, current charge was given to respondent number 4 for the purpose of administration. Fine. That was temporary. Even though it is for temporary, I have challenged because this honorable court has laid down the law that even for temporary charge, the seniority role should not be ignored. That is why I have challenged, but the finding has come. But ultimately, for regular process, it has to be done in accordance with rules, accordance with law. So that was the finding given in the writ appeal 28/2022. Now, argument has been advanced. This will be the last point. Argument has been advanced that the distinction has been removed by third amendment. Now, that is possible only when she holds a sanction post. Because she wants to make it equivalent with us. But unless she's in a cadre post, she cannot be. So I will just sum up with some rulings. May I cite the citations? Since we are running short of time, I will just cite the citations. Right to be created by service rule. Right to be created by service rule. 2017, 12 SCC. 2017, 12 SCC, 657. Paragraph 65. Right to be created by the service rule, not at the whims of anybody. Next. Next suggestion. Merely by holding temporary officiating charge does not grant promotion. That is 2021 12 ACC. I think I have already cited that. On the point of res judicata, 2016, 14 ACC, page 49. There are 4 paragraphs. Paragraph 11.1, 11.2, 15 and 16. And it is under opiter dicta. This is a judgment not reported in the SAC, but it's through online. Opiter dicta, it is in a criminal appeal. Number 1706 to 1708 of 2021.
2011.
Yes, 2011. Paragraph 26, 27, 28 and 29. Arun Kumar Agarwal versus State of MP. And then last, distinction between promotion and accreditation. Because on the basis of accreditation, the respondent number 4 is claiming that she is also eligible. So whether it will cover up or not, distinction between promotion and accreditation. 2011, 9 ACC 510, paragraph 29. Bharat Sanchar Nigam Limited. Distinction between promotion and accreditation. There is a vast difference between the two.
Lordship, just one clarification, 1 minute, Your Lordship, on selection and promotion, Your Lordship. The case of the petitioner is that though the post of secretary is selection post in the order to work promotion. Now, my submission is that though it is the promotion, Your Worship, the promotion is by way of selection. There may be two eligible candidates for promotion or three eligible candidates, but it will be by way of selection as deemed fit by the appointing authority. So just because it is a selection post in the promotion order, it will not be used that he is selected as secretary. No, promoted, but by way of
From which post?
selection. That is the clarification on promotion.
Another point, Lordship, which the council for the respondent number 4 has submitted was on the point of applicability of Rule 12 and 15. We are not saying that only Rule 15 will be applicable. Both Rule 12 and 15 will be applicable, but for different purposes. There is no conflict between these two rules. Rule 12 and 15. Both can be applied, but for different purposes. Because they have argued that one should be applied, one should not be applied. It's not that. Both are applicable, but for different purposes.
The judgment is reserved.
Lordship.
Much obliged, Lordship.
Highly obliged.
We are privileged for a very patient hearing.
Okay. Yes.
Me, please, my lordship. Lordship, I beg to mention item number 29. I am the petitioner, lordship. The respondent government has filed their affidavit in opposition. I want to file counter against the affidavit in opposition.
Reply.
Yes, counter. Then let them, by next week, after a long holiday, I'm in preparation. My lord, I will file by next week as early as possible. So let the matter be fixed as fixed item as admission
Cannot be fixed.
on third.
Next week.
On third, lordship, I have some other problem. On 3rd August.
3rd August.
Yes, lordship, as a fixed item.
On the day you will be filing the reply only.
I'm going to file a reply by next week, lordship.
Why?
I'm awaiting some documents.
MSZ Jimoni. Appearing for a petitioner prays for some time to file a reply in respect of the counter affidavit filed by the respondents. Her prayer is allowed after hearing both sides. List on 3rd of August.
As a fixed item, lordship.
Okay, all right.
Obliged, lordship.
My lord, I beg to mention item 17.
Yes.
I pray that 3 weeks time may be granted. I've sent the affidavit for waiting.
Okay. You were additional advocate general.
Yes, LD Sangdam.
The learned additional advocate general, Mr. L.D. Samtam, preparing for the state respondents, has submitted that the counter affidavit has been sent for vetting, and he needs 3 weeks time to file the same.
Lordship, can it be 2 weeks? Because last time also, twice they have taken time, and last time the respondent himself was asked to appear before this honorable court.
Initial stage, let him take 3 weeks. Hard MSZ Jimoni paying for the petitioner. The prayer of the state respondent is allowed, at least after 3 weeks.
Much.
I am respondent, lordship.
Wow. Hard MSZ Jimoni paying for the respondent.
I'm for the petitioner.
Hard Mr.
Tupanandam.
I pay for the petitioner. Prayer is allowed, least after 3 weeks.
Obliged, lordship.
Yes.
Please, your lordship.
Yes.
Lordship, I beg to mention item 7 on behalf of Pichano, government advocate. Pray for some time to file an additional affidavit. 3 weeks, your lordship.
You are for the petitioner,
For the response, state respondents.
or for a state respondent.
Yes, your lordship.
Have you filed a counter affidavit?
Yes, as per the last court direction, I had to
Oh.
instruct.
The learned counsel, Mr. So-and-so, appearing for the state respondents, has submitted he will be filing an additional affidavit, and therefore he needs some time. Hard MS so-and-so appearing for a petitioner. The prayer of the state respondent is allowed, at least after 3 weeks.
Lordship, I also like to mention item 10. 9 to 13 is analogous. I filed the affidavits in all the others except for 10. I
Except
pray
for
for 3 weeks, your lordship.
In item number 10, Mr. So-and-so appearing for the state respondent prays for some time to file the counter affidavit. Hard MS appearing for the petitioner. The prayer of the state respondent is allowed, at least after 3 weeks, along with item number 9, 11, 12, and 13.
Yes, your lordship. Lordship, I also like to mention item 18 on behalf of additional AG in himself.
Item 18.
Yes, affidavit has been sent for vetting. So I pray for some time, your lordship.
Lordship, here, last chance has already been granted on 18th. On 18th of May, my lord. And after that, again, another chance was granted to the state respondents to file the affidavit in opposition on
It is sent for-
16th of,
I think.
Sent for vetting.
16th of June, Lordship. Now,
One last chance I will give you.
my lord, but let them take sufficient time, my lord. But if on the next day, if the affidavit is not filed, it may kindly be recorded that cost will be imposed on the state respondents.
The learned counsel, Mr. So-and-so, appearing for the state respondents, has submitted that the APD counter affidavit has been sent for vetting, and the same will be filed within a short time. Mr. Santingar The learned counsel for the petitioner, on the other hand, reminded that the state has already taken several times. Where after hearing both sides, the prayer of the state respondent is allowed. One last opportunity is given by the petitioner, given to the state respondent to file the affidavit. If the state respondent fails to file the counter affidavit within next fixed date, the cost will be imposed. At least after 4 weeks.
Simply obliged.
May I please, Lordship?
Yes.
Lordship, my humble prayer to fix a date. It is supplementary hearing item 33. Supplementary hearing item 33, Lordship.
When do you want it?
August 20, Lordship. The petitioner has filed the affidavit, and this morning only I will serve a copy. So
Yeah.
I need some time to go through it and let the matter be fixed on August 20, Lordship.
You are for the respondent.
I am for respondent number 1, Lordship.
Next, Lordship. Lordship, I'm for the petitioner.
You are for the petitioner. The learned counsel, Mr. What is your name?
Sharif Ahmed, Lordship.
Ahmed. Appearing for the respondent submits that
Respondent number 1, Lordship.
respondent number 1 has submitted that the petitioner has filed what he has filed,
Affidavit in reply, Lordship.
or affidavit in reply, and therefore he needs some time to go through the same. RMS so and so appearing for the petitioner. The prayer, Mr. Sharif, is allowed. The hearing is adjourned accordingly. List on when do you want it?
August 20, Lordship.
20 August for hearing.
20th August.
Okay.
Obliged, Lordship.
Okay.
As of last one.
Yes.
Please, Your Lordship. Lordship, I beg to mention item number 19. Here I am for respondent, private respondent number 4. Kindly grant 3 weeks time to file our affidavit in opposition.
Respondent number 5.
For Your Lordship.
Respondent number 4.
My lord, small prayer. Lordship, I'm so sorry. Paragraph 5, one word, my junior colleague has mistakenly written girls instead of boys. So that word may be allowed to be corrected.
Okay, correct it. MS so and so appearing for the state respondents, or respondent number 4 seeks some time to file the counter affidavit. The learned counsel, Mr. So and so, you are age Joe.
Age of my lord.
A Joe, appearing for the petitioner, submits that there is a small typographical mistake in the petition, where
Paragraph 5,
in paragraph 5 of the
instead of boys, it is written girls.
there is a small typographical error in paragraph 5 of the application, where instead of boys within inverted comma, girls has been mentioned.
Yes, my lord.
Girls within inverted comma.
So it can be written.
The said error shall be corrected in the registry, and corrected in presence of registry officials. The prayer of the respondent number 4 is allowed, least after 4 weeks.
Majum.
May it please, Your Lordship. Lordship, I beg to mention item number 6, Your Lordship. We have instruction to appear on behalf of the petitioner, Your Lordship. If we may, since if the matter may come up after 3 weeks, since we'll be filing our Bakalatnama by today, Your Lordship.
So you are new lawyer.
Yes.
What is your name?
Kim Piana, appearing on behalf of N. Longkumar.
The-
Lordship, we are no longer engaged in this matter as petitioner. So if our name may be deleted from the cost list, Lordship,
You are PB Paul,
we people and
Poseka Pate.
Chupanangam,
Huh?
Chupanangam.
The learned counsel MS so and so, appearing for a petitioner, submits that she has been newly engaged in this case. On the other hand, Mr. What is your name?
Chupanangam.
Chuba Nungkum has submitted that earlier he and Poseka Pate,
All of the petitions.
Poseka Pate, PB Pal and Meadow Bharo used to represent the petitioner, but now they no longer represent the petitioner, and therefore their name should be deleted from the cause list. Para. After hearing the learned counsels, the names of Mr. P.B. Pal, Osikopote, Subanunkum, and Meadow Bharo shall be deleted from the cause list as the counsel representing the petitioner. In their place, the names of MS,
Kim Pena,
Kim Pena,
appearing on behalf of N. Longkumar.
and Longkumar shall be shown in the cause list as the counsel for the petitioners. List after 4 weeks.
Pleasure, Lordship.
May please, my lord.
Yes.
My lord, I beg to mention item number 6. My lord, here we have received
6 is already adjourned.
item number 6.
6.
6.
The last item was 6. Last item was 6.
Yes, it is item number 6, sir.
6. It is already adjourned.
Much worship.
May please, Your Lordship. Lordship, I beg to mention item number 5. Lordship, we may be granted 2 weeks' time to file a reply to the affidavit filed by the state.
Okay, what is your name?
Esther, Your Lordship.
The learned counsel MS Esther,
Yes, Your Lordship.
appearing for the petitioner submits that she needs some time to file a reply in respect of the counter affidavit filed by the
State.
state respondents. Heard Mr. So-and-so, you are additional advocate general.
Yes.
Heard the learned additional advocate general, Mr. So-and-so, appearing for the state respondent. Heard MS.
Appearing on behalf of respondent number 7.
State respondent 1 to 6 and MS so-and-so appearing for a respondent number 7. The prayer of MS Esther is allowed. List after 4 weeks.
2 weeks, my lord.
2 weeks.
There's an interim.
The interim order past trial will continue till the next date of listing.
Much obliged. Much Lordship.
Yeah, Miss Lordship, Your Lordship, I beg to mention item number 16.
16.
Yes, Your Lordship. Your Lordship, we are yet to file our reply, so I may be granted 3 weeks to file reply.
Reply. What is your name?
Sekmo.
The learned T Sekmo.
Yes, Your Lordship.
Tekmo Sang.
Sekmo Chan.
Long name. MST Sekmo Chang. Appearing for the petitioner, prays for some time to file a reply in respect of the counter affidavit filed by the state respondents. Heard MS so-and-so appearing for the state respondents. The prayer of MS Chang is allowed. List after 3 weeks. Yes.
Lordship, I beg to mention item 14 and 15, Lordship.
14 and 15.
Yes, Lordship. In item number 14, Lordship, I have received instructions, Lordship. But in item 15, I'm yet to receive the instructions, Lordship. So in 3 weeks' time, it granted to me, Lordship.
In item number 15, you write.
In 14.
14 you have already received.
Yes, Lordship.
Counter affidavit not filed.
Not filed.
In item number 14, you write. MS so-and-so appearing for the state respondents. Prays for some time to file the counter affidavit. Heard MS. You are for a petitioner.
Lordship, I'm for the petitioner, item 14.
What is your name?
Asana S. Alkia.
Appearing for a petitioner. The prayer of the state respondent is allowed. List after 3 weeks along with item number 15.
Lordship. Lordship, I also beg to mention item 20, 21, 22, and 23, Lordship. Here, also Lordship,
Hmm.
in item 20 and 21, Lordship, I have received the instructions.
Hmm.
But in 22 and 23, I'm yet to receive the instructions, Lordship.
Item 20, right? Hard MS so appearing for the state respondents. The what was your earlier item? Last item, what was the last item?
Item 16.
16. No. Hard MST Sem Sekmon Chang. Appearing for the petitioner. The learned council's appearing for the respondent, state respondent, prays for some time to file her counter affidavit. After hearing both sides, her prayer is allowed. Least after 4 weeks, along with item number 21, 22, and 23.
Lordship. Much obliged, Lordship.
Please, Lordship,
Yeah.
Lordship, I beg to mention item number 8.
8.
Yes. Lordship, here in this case, I pray that the matter will be listed after 3 weeks.
Okay. The learned senior government advocate,
Additional AG.
additional advocate general MS Sukre,
Yes.
appearing for the state respondent, prays for some time to file the counter affidavit.
Already filed, Lordship.
Already filed.
Yes.
Now, what do you want?
Lordship, pleadings are completed, so
Oh,
the matter may.
Now, hard the learned additional advocate MS Sukre, appearing for the state respondents, hard MS Esther, appearing for the petitioner. The pleadings are complete. List this matter for hearing after 4 weeks.
Please, Lordship.
Yes,
Lordship, I'd like to mention item number 24.
24,
No, Lordship, 25, Lord.
25.
Yes.
Mm.
I'm representing all the respondents in this matter, Lordship. I'm yet to receive instructions. So I pray that another 2 weeks may be granted.
Lordship, I am appearing for the petitioner in this matter.
For a petitioner.
Yes, Lord.
The learned counsel, Mr.
Is that cool?
Z.
Is that cool? Stand.
Just to move. For the respondents, prays for some time to take instructions. Hard Mr.
P. Jalan.
P. Jalan. The prayer of the learned counsel for the respondents is allowed. Least after 3 weeks.
Obliged, Lordship.
May I please your Lordship? Lordship, I beg to mention item 26 on behalf of my senior, Gauhati. Lordship, we are yet to receive instruction in this matter, so if your Lordship may kindly grant us 4 weeks then.
Okay. Mr. So-and-so, appearing for the state respondents.
For the union, Lordship.
Huh?
Respondent 1 to 3 for the union.
For Union of India. Prays for some time to take instructions. Hard Mr. Muajami, appearing for the petitioner.
My lord, I'm appearing for respondent number 5, 4, 5, and 6.
Hard Mr.
State
So-and-so,
respondent.
appearing for the respondents 4, 5, and 6.
I'm yet to receive instruction. my lord. 3 weeks.
The prayer of the Lord. Least after 4 weeks.
My lord. 27 and 28, Lordship. Lordship, in this case, we steps on respondent number 10 in item number 28, Lordship. By way of justice service, Lordship.
You want to take steps?
Yes, we have already initiated the steps, but the respondent, he has refused to accept the notice, Lordship.
Then you file the affidavit.
Lordship, yes, we'll file an affidavit. In the meantime, if we may be allowed to take steps by way of substituted notice, Lordship.
If he has refused to accept the notice, then substituted service is not required.
Lordship, paper publication, Lordship.
Or paper publication.
Yes, Lordship.
Item number 27. Mr. Muajami, the learned counsel for a petitioner, submits that a respondent number 11 has refused to accept the notice when the notice was wanted to be served upon him. Therefore, Mr. Jamil submits that he will take steps for service of notice upon the respondent number 11 by publishing the same in a newspaper, local newspaper. RMS.
Lordship, Apila Sankam for respondent number 10 in item number 27.
Apila Sanctum, appearing for respondent number 10.
In item number 27, and I respondent number 9 in item number 28.
Okay.
My lord, I'm appearing for all the state respondents.
Hard the learned additional advocate general Mr. So-and-so, appearing for all the state respondents. The prayer, Mr. Jamil is allowed. The notice will be published in the local newspaper within the month of August.
Lordship, if a returnable date may be fixed, Lordship.
Within the month of
Second week of August, Lordship.
13 August.
Lordship.
13 August. This matter will be listed again on 17 August.
Lordship.
In item number 28, same order, instead of item respondent number 10, it is 11, it is
Respondent 10.
respondent number 10.
Lordship.
Same order will be done. And Apila Sanctum is appearing for respondent number 9.
9.
Okay.
Lordship.
Obliged, Lordship.
May I please your lordship?
Yes.
Lordship, I may kindly be permitted to mention hearing item 31. Lordship, if the matter can kindly be fixed on 23rd, next Thursday.
You do it after that.
Then 27th, my lord.
7th. Mr. Santinga, the learned counsel for the appellant, prays for an adjournment. Heard Mr. So-and-so, the learned public prosecutor for the state of Nagaland. The hearing is adjourned accordingly, listed on
27th, my lord.
27th July
My
for
lord.
hearing.
My lord. Deeply obliged. Much honored.
May I please your lordship? Lordship, with regard to item number 30, my senior Alan K. My sir is also there. My lordship, this matter will take considerable amount of time today, and I am appearing through VC. So, my lordship, can this matter be like taken on another day so that I can appear? Actually, to VC, it will take certain amount of time also. My senior Alan K. My sir is also there. If sir has no objection to it. And
You are for the appellant.
I'm for the petitioner, my lordship, because it's a criminal petition. As
Yes.
because court number 2, she was I have earlier appeared in this matter, so not by honorable court number 2, and it has been transferred to an to court number 1.
You want to come to Kohima?
My lordship, yes. And like if it on 10th of July, August, or like on 24th of August, if another date on these 2 dates can be accommodated, because it will take considerable time to VC.
Do you have any objection?
My lord, I'm for the respondent number 2. My lord, this case has been waiting for the last 6 years. So
6
this
years?
is, yes, because
Very
the
long time.
opposite party has been playing this delaying. So this
One
was
last
the
chance.
chance that the council also,
It's the 2024 matter.
in her absence, so I have to take up. That was the word we do. I've been traveling from Dimapur up, down, and for many times.
You come
So
to
the word also we have already fixed that. In her absence, if
Then
someone
my lordship, through BC, if sir has objection, I can appear today through BC, my lordship.
Okay.
BC, because but it will take time, so that's why my lordship, since already first of was there, so I was making a prayer.
If you cannot come personally, you do it by VC.
My lordship, today itself, my lordship.
Today not possible. So on some other day.
Yes, my lordship. Then can it be on my lordship 10 or 12 of 10 or 24 August, any of the 2 dates, my lordship. 10 August or 24 August.
my
Choose a former party, so I have no objection.
Okay. MSSZ Borwa, appearing for the petitioner, prays for an adjournment on the ground that she wants to come personally to Kohima to take part in the hearing. The learned counsel, Mr. What is your name?
my lord,
Yes.
Kamaya Lin, respondent number 2.
Coming Elin Rongmi, appearing for the respondent number 2.
My lord, I objected and I pray for the cause because this is too much
has
harassment.
objected to the said prayer on the ground that the petitioner has taken several adjournments. Fair. After hearing both sides, one last opportunity is given to the petitioner to take part in the hearing. List on 10th of August for hearing.
My lordship, 8 is Saturday, my lordship, 8 August is Saturday. 10 August,
10th is what?
10 August, my Monday.
Monday, do it on Monday?
My lordship, 10 August.
10th of August.
My lordship, there is an interim order.
The interim order parcel shall continue till the next date of listing.
Obliged, my lordship.
Well, more or less.
Principal seat, motion bill, item number 1.
Number 1. PCR health status. My lord, here, my lord, with all respect and full hands, my lord. Answer.
Yes.
Yeah, my lord, with all respect, my lord, 1034, what has happened, my lord? The accused, his wife was having an extramarital affair. Upon coming to know about it, my lord, the lady was butchered, my lord. And at the same time, possibly by the same knife, he also, my lord, with all respect, stabbed himself, my lord. And attempted to commit suicide, my lord. Now CS has been submitted, my lord. He's still in hospital and deteriorating, my lord. So hence, my lord, the scan copy of the charge sheet, because charge sheeted, my lord, and a medical report from the hospital, my lord, these two, my lord. Jail hospital, my lord. Any convenient date, my lord.
Okay. Heard Mr. B.K. Mahajan. B.K. Mahajan, appearing for the petitioner.
Yes, Doctor.
Heard Mr. P.S. Lawcourt. The learned additional public prosecutor for the state of Assam.
Yes, Islam.
Huh?
Mr. S. Islam for informant.
Heard Mr. S. Islam. S. Islam appearing for the informant. Call for the
Scan copy, my lord.
scan copy of the trial court record.
My lord, my lord.
When it will come?
Any
In the last week, I shall be coming.
Then or last.
Yes, my lord. Yes, my lord.
Do it on the last week.
My lord.
13th of July.
30th of July, my lord.
30th of July.
30th of July. One of the health report as well, my lord.
Call for a scan copy of the trial court record along with
Health report of the accused, my lord.
health report of the petitioner from the jail authorities.
My lord, my lord, my lord.
Registry will call us.
Huh?
Registry will call us.
List on 30th of July.
My lord. My lord, registry will call, my lord, with all respect, my lord.
Registry will automatically call.
My lord, my lord.
Item number 2.
Go, my lord.
May it please your lordship. My lord, 483 bail application, my lord. The petitioner was arrested on 13/4/2026, my lord. Today is, my lord, 95 days, my lord.
Is this the second application?
Yes, my lord. This is the second bail application, my lord. And today is the 95 days, my lord. The statutory period has already been, my lord, completed.
Over.
CS is pending, lordship.
Huh?
CS pending, lordship.
Process not yet filed.
Not filed, my lord.
Heard Mr. N. Sarkar, appearing for a petitioner. Heard Mr. P.S. Lawcourt, the learned additional public prosecutor for the state of Assam. This is an application under section 483 of the BNSS 2023, whereby the petitioner Anil Burman has prayed for releasing him on bail after he was arrested in connection with Bongaigaon PS case number 56 of 2026. Today is the 95th day of detention.
Yes.
No charge sheet has been filed. Therefore, the petitioner is entitled to default bail. the petitioner Anil Burman shall be released on bail of rupees 25,000 with a surety of like amount to the satisfaction of the learned Chief Judicial Magistrate, Bongaigaon. With the aforesaid direction, the bail application is disposed.
Much obliged.
Item number 3.
May I please, your lordship? Lordship, I am up here again, missing on the order dated 24/6 passed by this honorable court in bill.
In
petition
lordship,
number.
Poxo method, lordship, notice should go first, lordship.
Then the statutory period, if it would have been registered under section 108 BNS, FIR is at page 16 to 17 apparent, my lord. And nobody was present at the time of occurrence, at the place of occurrence. Other family members have not been arrested because he is the husband, hence he was arrested, my lord. And FIR is from begins at page 16 to 17, my lord. And 64 days already inside, and it's a clear-cut case of suicide apparent on face of the record, my lord. If it is 16 to 17 read, my lord.
So here in this case, lordship, we have received the PM, but the opinion is reserved because of the FISARA report, lordship. FISARA report is FSL, FISARA report is awaited, lordship. And
my lord, Viscera possibly may not be, of course, I'll not go into that, my lord, lordship, but kindly look at page 16 to 17, apparent, my lord. Nobody was present at the time of occurrence, at the place of occurrence. She committed suicide. Given the shape, my lord, all of the allegations were given that earlier she was beaten up. Hence, 103 was inserted, my lord. With all respect, 64 days.
Let me go through the FIR first.
My lord, with all. It begins at page 16, my lord. Married, my lord.
Yes, yes.
If it's a lengthy one, my lord, this paragraph may not be so important, my lord. Can I turn the page, my lord?
You read it from the beginning. It's a very, very long FIR.
Long, exactly, my lord. I read from page 17, my lord.
No, you read from page 16.
16, I leave aside, my lord.
No.
Beginning.
You read
I'm sorry, my lord. Most respectfully, beg to state that about 8 years ago, the marriage of my niece, namely Uma Hani Usmani, was solemnized with accused number 1, and he starts a marital life with accused number 1 at his residence. After the marriage, the accused number 1 and 5 did not allow my niece to talk to anyone or visit the house of any relative and kept her confined within the four walls of a house all the time. The accused persons also did not allow my niece to use any phone, and she could only talk to anyone in presence of accused number 1, the husband, my lord, who is inside, by using his phone. When my niece protests against such conduct and action against accused number 1 to fight, accused number 1 often used to beat her. My niece gave birth to a son who later died. Thereafter, my niece gave birth to another son who is presently about 5 years old. Meanwhile, accused number 1 started to build a shop house to run business at Kalaghat Bazaar, and for this, accused number 1 and 5 asked my niece to bring 5 lakh rupees from her mother and relatives. When my niece refused to bring the money, accused number 1 to 5 used to beat her. In this way, accused number 1 to 5 continued to inflict physical and mental torture upon my niece. In the first week of last February, this is a separate incident, my lord, at the instigation and with the cooperation of accused number 2, 3, 4, and 5, accused number 1 asked my niece to bring 5 lakh rupees. When she refused to bring money, accused number 1 beat her and caused injuries on her head by punching her randomly and pressed her throat in an attempt to kill her. This is, my lord, the separate incident few months back, my lord. Allegations. Thereafter, my lord, my niece somehow freed herself from the clutches of the accused persons and saved her life by locking herself in a different room. In the week before Eid ul Fitr, at the instigation with cooperation of accused number 2, 3, 4, and 5, accused number 1 beat my niece and drove her out of the house. Earlier incident, my lord, 498A. Accused number 1 beat my niece and drove her out of the house. Being helpless, my niece took shelter at her mother's house. On 23-26, accused number 2, 3, my lord, other family members came to my sister's house and took my niece back to their house. On last 22-4-26, in the morning at about 10:15 p.m., we received information from one of our neighbors that my niece's dead body was lying in the house of accused persons. Upon receiving this information, I, along with my sister Akima Bibi, so-and-so, went to the house of the accused persons and found my niece, it is very important, my lord, present incident, and found my niece's dead body lying on a bed inside a room of their house, but did not find any of the accused persons there. We saw all the rooms under lock and key except the room where the dead body was kept. On being informed about the incident, the police arrived. Magistrate also came in the evening time. At the demand of rupees 5 lakh by accused so-and-so, so are not fulfilled, accused number 1 to 5 with the help of accused number 6, 7, tortured my niece Uma Ana Yustami physically and thereafter killed her. Because of this word, my lord, 103 was inserted. With all respect, my lord, it is a clear-cut case of 108. Husband was not there. And to be that it is a case of 108, my lord, other female members have not been arrested. Only the accused has been arrested. And so far as, my lord, 108 is concerned, had it been 108, it would be a case of 60 days, my lord. Now 64 days inside. With all respect, my lord.
What is there in the case date?
Lordship, as per city lordship, some witnesses' statements has been recorded, lordship, and there's most of the witnesses are neighbor person, and but they have come after hearing the hue and cry. But one witness, lordship, she is Asma Bibi, and she is the maid of their house. As per her statement, lordship, in the morning she took tea along with the deceased, lordship, and subsequently the present accused person went to school, drop her son in the school, and when she came into the room of the deceased, she found that she is hanging in the fan. That must be
Hanging,
lordship.
Oh, she was hanging.
Hanging, lordship.
Hanging.
So, lordship, and lordship, even in postmortem report, lordship, that there was no any injury found, lordship. That must, lordship, except the fishery report, lordship.
But it's not a case of poisoning, my lord, that viscera is needed. She died by hanging. Husband was not there, my lord. Apparent, my lord.
I heard Mr. B.K. Mahajan appearing for the petitioner. Heard Mr. P.S. Locker, the learned traditional public prosecutor for the state of Assam. This is an application under section 483 of the BNSS 2023, whereby the petitioner Ali Hussain has prayed for releasing him on bail after he was arrested in connection with Dhubri PS case number 146 of 2026. There, in the FIR, it is alleged that the petitioner and his family members used to physically and mentally harass the deceased, who was the wife of the present petitioner. In the FIR, it is further alleged that an amount of rupees 5 lakh was demanded from the deceased woman, and when she refused to pay the money, she was mercilessly beaten up. According to the informant, on 22/04/2026, he came to know that the dead body of the deceased was lying in the house of the present petitioner. There. The case diary shows that the deceased died because of hanging. Where Mr. Mahajan has submitted that this is not a case under section 103 of the BNS. Rather, it is a case under section 108 of the BNS. Where under the given circumstances, this court has decided to agree with Mr. Mahajan. If it is held to be a case of suicide, the petitioner is entitled to default bail.
My lord.
After considering the matter in its entirety, it is decided to allow the prayer of the petitioner. The petitioner Ali Hussein shall be released on bail of rupees 25,000 with a surety of like amount to the satisfaction of the learned Chief Judicial
DGM Dhubri, my lord.
Dhubri, Chief Judicial Magistrate Dhubri. The bail application is disposed of. Oh, it is a AB.
BA, my lord.
Yeah, AB or
64 days, my
oh, BA.
BA.
Oh, the case diary shall be returned.
Highly obliged, my lord. Highly obliged, my lord. Highly obliged, my lord.
For motion, item number 1.
Wait, Your Lordship. Lordship, here the petitioner is seeking direction for release of his salary and also praying for quashing and setting aside the letter dated 3 of September 2024, withholding the salary of the petitioner, Lordship.
Yes, salary.
Yes, Lordship.
Okay, you take instructions. Hard MS.
Mika Iche.
Appearing for the petitioner. Hard Mr. So-and-so appearing for the state respondents. The learned counsel for the state respondents has prayed for some time. And right one. No formal notice is required to be sent to the respondents. As because Mr. So-and-so has accepted notice. The learned counsel for the state respondents prays for some time to take instructions. After hearing both sides, his prayer is allowed. Least after 3 weeks.
Item number 2.
Yes.
My Lordship, here the present matter involves some urgency, Your Lordship. So the petitioners are before this court. Lordship, here the the petitioner's late grandfather, Your Lordship. In the early 1950s, it donated a small portion of land to the government for establishing a government middle school in Chetima village, Kohima. So on the basis of that, the petitioner number one, he was given appointment by the Department of School Education. So while serving under the state department, one writ petition was filed before this court, which was registered as WPC 73 of 2018. And then the petitioner number one in this present writ petition was implemented as respondent number 4 in that particular writ petition, where the petitioner challenged my appointment order on the basis that the petitioner should be appointed on compassionate ground. So well, that particular WPC 73 of 2018 was pending before this noble court. Now the village authorities, that is the Chidima village, my villagers, they issued one resolution stating that the land which was donated by my late grandfather was donated to the community. So the land belongs to the villagers. So on the basis of that, again, I filed one writ petition, that is the WPC 110 of 2018. So the matter, the issue involves same to the WPC 73 and WPC 110 of 2018 was heard together. Then may I take you that particular line, annexure 1, page 12.
The resolution.
This honorable court order.
No, you show me the resolution first. Where is the resolution?
Your Lordship, the earlier resolution.
The resolution dated 05.
Page 18, page 18. Page 18 in the court's order, paragraph 9. A, may I read, Your Lordship? Resolution date 3/7/2016 adopted by the Chitima village authorities declaring that the land where the GMS Chitima and the local ground has been constructed is the common land of the village and no land ownership certificate can be issued to one particular clan or person. So after hearing this, Honorable Court, Your Lordship, has passed a direction to the Deputy Commissioner, that is page 9, page 22. May I read, Your Lordship, page 22, para 19, the relevant part.
Page 22.
Yes, paragraph 19. May I read, Your Lordship? The Deputy Commissioner Kohima shall accordingly make a detailed inquiry on the ownership of the land where the GMS Chitima is located with the participation of all the stakeholders, including the petitioner, the village authorities, and the clans who have donated the land for the school. On completion of the inquiry, the Deputy Commissioner Kohima shall submit his findings to the Government of Nagaland, Department of School Education. This exercise shall be carried out and completed by the Deputy Commissioner Kohima within a period of 90 days from the date of this judgment. This was the order passed by the this Honorable Court and the earlier proceedings. So after that, the Deputy Commissioner submitted the inquiry report. So for easy reference, I also include the inquiry report, Your Worship. Annexure 3, the relevant part is at page 34. Page 34. The last paragraph, Your Worship, I'll just read the relevant part. May I read?
Page number?
34. Inquiry report submitted by the DC.
Yes.
On the last paragraph, Your Lordship. Considering the above facts and circumstances, it may be reasoned that the ancestral landowner of the plot of land where the present GMS stand is Let Zipu Chakroni and his family, that is the petitioners. However, by virtue of donation for the development of community assets, property, the present owner is the community. This was the report submitted by the Deputy Commissioner. So for the second time again, the petitioner approaches Honorable Court by filing two writ petitions, that is WPC 297 and 298 before this Honorable Court. And then at the time of the hearing, since the matter involves some caution of facts to be settled, Your Lordship, I was directed to approach competent court of civil jurisdiction. So the relevant court order is at page 24, annexure 2.
You filed a suit?
No, before filing the suit.
Oh, it's
Page 32 is the relevant, this honorable court order. Page 32. Dated 27/11/2025. I'll just read the last paragraph, Lordship. Accordingly, the above noted petition stands dismissed on withdrawal with liberty reserved to the petitioners to institute appropriate proceedings before the competent court of civil jurisdiction, if so advised. So, since liberty was granted, Your Lordship, I filed a civil case before the Honorable Civil Judge Senior Division Kohima Nagaland on 29 of May 2026. And then it was registered as declarative suit number 1 of 2026. Annexure 4, page 35.
Yes.
Dated 01/06/2026, received declarative suit number such and such filed by the plaintiffs. And then I'll just read the paragraph number 2 and 3. Heard Leonard Counsel such and such for plaintiffs, produce the plaint in the next year's plaintiff to take steps for issue of notice upon the defendants along with a copy of this order and the plaint. Number 5, fixed on 15/7/2026 for appearance or service report. That is, yes, it was listed yesterday. But then, Your Lordship, after the filing of this civil case before the Honorable Civil Senior Division at Kohima, now the respondent number 3, who is also a party in the civil suit, respondent number 3, that is the village council, they issued one resolution which has been challenged under this present writ petition. Annexure 5, page 36. Annexure 5, page 36. Lordship, my translated copy is at page 40. Lordship, this is important, so I'm allowed to read all the contents, Lordship. Office of the Jitima Village Council, dated 5/7/26, Village Resolution and Decision. The Jitima villagers are aware of the dispute relating to land ownership of the plot of land where the government middle school Jitima is located. Late Zipo descendants have filed a case claiming for land ownership before the court for more than 10 years and for which the development for the school has been stopped. Again, a case has been filed before the civil court by late Zipo descendants. Accordingly, on 20th of June 2026 and 5th of July 2026, meetings were held at Malor Indoor Stadium and Panjat Hall, whereby village council members, school management committee, Conpro organization, president of the 8 clans, village development board, Jitima Village Students Union, Jitima Village Youth Organization, Jitima Women Organization, Jitima Cases Officers Organization, and Pensioners Organization attended the meeting. And then it was decided that the land where the present government middle school Jitima stands in its surroundings was given by late Zibu, that is the forefathers of the late Zibu descendants, to be a public property. On 3rd of July 2016, the village leaders hereby strongly uphold the same resolution. Passing on the meeting resolution dated 11/8/2019 in 14/1/2024, duty on the 5th of July 2026, the village leaders in its meeting decided that late Zipu Chakundo descendants should obey or follow the resolution of 11/8/2019 and 14/1/2024 before 15/7/2026, that is yesterday, Lordship. In the event of disobedience, the following action will be taken against the descendants of late Zipu Chakundo with effect from 16/7/2026 from today, Lordship. Number 1, they will lose all the rights and benefits given by the government in the village. Number 2, no documents will be issued by the village authority to the descendants of late Zipu. Number 3, late Zipu descendants will be barred from holding any leadership post in the village. 4, any person who takes the side of late Zipu descendants shall also be punished with the same consequences. And 5, for any necessary steps to be taken, the village leader will decide for the welfare of the people. Lordship, this particular resolution was received only by me on 8th of July 2026, Lordship. And then even when this resolution was made, all the authorities were called upon, but we were not called upon by the village council, Lordship. It was decided on their behalf. And then having known that a civil case has been filed before the district court, Lordship, for determining the land ownership, Lordship, but they've illegally passed this ambient resolution. And then having no alternative, Lordship, the petitioner submitted one representation to the Deputy Commissioner. Annexure 6, Lordship. On 13/7/2026, Lordship. The DCP, the administrative head, he submitted a representation to the Deputy Commissioner seeking for appropriate steps since they have received that ambient resolution, Your Lordship.
Okay.
After that, as per the resolution, the deadline was till yesterday, is 15. Last evening around 6:30, I received a copy in reply to the representation at 6:30. So I may be allowed to place before this court, lordship. May I read, lordship? Government of Nagaland, Office of the Deputy Commissioner, Kohima, Nagaland, order dated 15 July 2026. Whereas a representation dated 13/7/2026 was submitted by Shri Delhokri Chakrono and 7 others, seeking necessary steps as per law to avoid illegal actions arising from a resolution passed by the Chitima Village Council on 05/07/2026, which imposed specific terms on the descendants of the late Sepu Chakrono for compliance before 16/7/2026. And whereas the same applicants have already instituted formal legal proceedings against the Chitima Village Council and 14 others currently pending before the Court of the Civil Judge Senior Division Kohima, registered as declaratory suit number 1 of 2026 and miscellaneous application number 28 of 2026. Now, therefore, since the subject matter of the dispute is subjudiced before a competent court of law, Shri Delhokri Chakrono and the 7 other applicants are hereby advised to approach the aforementioned civil court to seek appropriate interim relief or any other remedies. Lordship, I received this obvious letter, Lordship.
Did you approach the civil court?
Lordship, no, Lordship.
You should go.
Yes, pardon your Lordship, as per the resolution, effective date is to be started from today, Lordship. So, having no alternative, the petitions are before this court, Lordship. And
you should have visited the civil court. Why you did not go to the civil court?
Lordship, before approaching the civil court, your Lordship, deceiving the appellate authority, I submitted representation, Lordship, and they have also clearly stated that to the first civil court, your Lordship. But at this juncture, your Lordship, there is an urgency, your Lordship, because which I've shown in the resolution, even resolution, they have laid on 5 criteria, Lordship, in the event of non-disobedience, your Lordship. They obviously say that you will lose all the rights and benefits. Secondly, no documents will be issued.
What is the urgency?
Lordship, if an interim order is not passed today, Lordship, these all actions will be taken by the respondents, Lordship, against me.
What type of action may be taken?
Firstly, my descendants, the petitioner's descendants will be barred from holding any leadership post in the village. Number 2, no documents will be issued by the village authority, Lordship. Thirdly, they will lose all the rights and benefits given by the government, your Lordship. And then at present, it's very clear that for determining the main issue, who is the genuine landowner of the land, it's before the civil court, your Lordship.
There is no urgency here. You take instructions.
Yes.
Hard, Mr. What is your name?
Sabamati, your Lordship.
AP for the petitioner. Petitioners. Hard, Mr. So-and-so.
Correspondent 1 and 2.
The land government report.
Yes.
AP for respondents 1 and 2. Issue notice. No formal notice is required to be sent to the respondents 1 and 2 as because Mr. So-and-so has accepted notice. Extra copy of the petition shall be provided to him. The petitioners shall take steps for service of notice of the respondent number 3 by speed post. Least after 2 weeks.
Lordship,
Much obliged.
For motion, item 3 and 4.
Please, Your Lordship.
Yes.
Lordship, this IA 153/2026 is for amendment of the petition, my lord. As set out in paragraph 5 of my application, my lord.
Paragraph 5.
Yes, Your Lordship.
Sukri, do you have an objection?
Lordship, yes, I have an objection. So this notice may be issued and 4 weeks time may be granted to us to file our objection, Lordship.
RMS S3rd. AP for the applicant. RMS Sukri. The learned counsel AP for the
Respondent number 1 to 5.
respondents 1, 2, and 5.
1, 2, 3, 4, and 5.
1, 2, 3, 4, and 5. Who is for Union of India? Hard, Mr. So it's appearing for?
Gauhati learned CGC.
CGC, you can appear for 7, 8 also. 7 and 8 also. Appearing for the respondents 6, 7, and 8.
7, 8.
Issue notice. No formal notice is required. Yes.
And for the respondent, private respondent number 9.
Hard MS so appearing for the respondent number 9. Issue notice. No formal notice is required to be sent to the respondents because The learned counsels representing the respondents have accepted notice. Extra copy of the petition shall be provided to them. MS Sucre has praised for some time to file an objection. After hearing both sides, the prayer of the learned counsel for the respondent is allowed. Least after 3 weeks.
4 weeks.
4 weeks.
Multiply.
Lordship, in item 4 also, IA 154, similar for implement, for amendments.
So then item number 4 also same order.
Same order, but different respondent number.
Oh.
So for respondent 1,
So
2, 3, and 4.
Item number 4.
No. 5, 6, 1,
50.
1, 2,
50. There is an I. I number 50. I number 50. I do. No. Oh, no. Oh, 154. In I number 154, RMS Esther appearing for the applicant. Hard MS Sucre. The learned counsel appearing for respondents 1,
2, 3, and 4.
1, 2, 3, and 4. Hard Mr. So-and-so appearing for the respondents 5, 6, 7. Hard MS so-and-so appearing for the respondent number 8. Issue notice. No formal notice is required to be sent, as because the learned counsels representing the respondents have accepted notice. MS Sucre has praised for some time to file an objection. The prayer is allowed least after 4 weeks.
Multiply.
From the supplementary cost list for motion item number 32.
Lordship,
Yes.
here I have a very limited petition. I am merely asking for a small direction from this honorable court to the respondents to disperse my representation. To consider my representation, Lordship. My representation is at Annexure 4, page 17.
Page 17.
Yes, my lord. This has not been considered, has not been disposed, Lordship, by the state respondents.
Bring for appointment.
Yes, Lordship. Here in Nagaland, as my lord is well aware, we have a policy where landowners, they themselves or their children are given appointment on land ownership basis, my lord. Now I have donated the land on which the rural development quarters are established at Changdongya.
So then I will ask them to dispose of your application.
My lord. A small direction may be given, Lordship.
Hard Mr. Santinga, the learned counsel appearing for the petitioner. Hard MS so-and-so appearing for the respondents.
1 to 6.
1 to 6. This is an application under Article 226 of the Constitution of India. Praying for a direction to consider the representation filed by the petitioner before the Director, Directorate of Rural Development, Nagaland, Para. The petitioner filed a representation praying for appointment on land ownership basis against the vacancy to be created after retirement of one Sri
Lanunong MTS stands for multitasking staff.
Lanunong Stam.
This is a great purpose.
Multitasking staff from RDB Changtong.
Yes. Rural Development Block, Changtongya.
Rural Development Block, Changtongya. The said application is still pending without consideration. Fair. I have considered the submissions made by the learned counsels of both sides. The respondent, who we consider number 4.
Yes, my lord, number 4.
The respondent number 4, Directorate of Rural Development Department, Nagaland, is directed to consider the application of the petitioner, said application of the petitioner within a period of 30 days from
My lord.
today.
My lord.
No, 30 days from the date of receiving this order. With aforesaid direction, the writ petition is closed and disposed of.
Deeply obliged, my lord.
For admission, item number 24.
Maybe, Sir Lordship.
Yes.
I find my affidavit, Lordship. I have bringing objection regarding the materiality of the present petition, Lordship.
So on the
non-tenders of necessary parties. Now the petitioner has come before this court seeking a direction for defreezing of his account. Now, Lordship, the freezing of account has been done on the direction of the RBI, Reserve Bank of India, Lordship, and the Axis Bank. Now the petitioner has an account with the Axis Bank, the Mapu branch, Lordship. Now, cyber scam, Lordship. Huge amount has been transacted through this account. And Lordship, and there are a number of cases pending throughout the country. Now the matter is under investigation.
We will hear you.
Your Lordship, one small submission. Sir, your Lordship, this writ petition is not challenging or to set aside any investigation. Your Lordship, whatever I am saying in this writ petition is that the line amount which has been disputed to be set aside and let the petitioner enjoy whatever he have the balance in his account. Your Lordship, I am willing to.
On 29, we will hear you. Leave this matter on 29
Lordship.
July. Please. Huh? Please. 29. Okay then.